Docket number 37, Your Lordship. Not it. Keep your.
My lord, a poll duty, my lord, applied for Vasundhara scheme. Despite there is a protection given by this honorable court, my lord. In spite of my lord disposing of that, my lord, in a very filmic matter, my lord, that one part of the residence has been dismantled, my lord. Now, rest part they have threatened that they will be dismantled at any moment, my lord. No so good, nothing has been issued, my lord. But my prayer is that is a matter of eviction, lord. May I take a unlisted matter 2 p.m.
Why you are mentioning before this court?
It's a bench 5 matter.
This is bench 5 is that they another bench 5.
Please, Your Lordship, I'm back to mention item number 48. So here the petitioners, they have asked to withdraw the petition, Your Lordship. So I'm appearing on behalf of the petition. So the matter may
Item
be
number
withdrawn.
48.
Yes.
What is the order? It have been complied with? Has it been complied with?
They have not instructed regarding that. They have not intimated, but they have said that they want to withdraw the matter. They want to not pursue.
Take up the matter when it starts withdrawing this matter. Contempt matter can't be withdrawn unless.
Item number 49, my lord. I need to file our reply affidavit, my lord, against the affidavit in question.
Quick time grant.
Yeah, please. I beg to mention item 29. In this case, 29. In this case, Lordship, we have a file affidavit in position is being filed today. So Lordship may allow
Who is that?
the respondent 2 and 3.
By that.
And my
It has not been filed, I think.
It's a filing today.
I have got a petition. So it may come on the court of March matter. It's not it.
The request the matters. Affidavit be filed on behalf of the by the 2024. By the Liberty file by
11 March.
Yes.
May I please, Lordship, I beg to mention item number 32, Lordship. Lordship, we have already filed an affidavit, Lordship, but the thing is that, Lordship, the mother of my senior is admitted in Bangalore, Lordship. So, Lordship, that senior could not appear for today, Lordship.
you are paying for whom?
G. Bora.
What happened?
Kindly adjourn the matter, Lordship, 19 February.
You have taken the permission from the other side? No.
Please, Lordship. Lordship, in item number 22, we have filed an affidavit, my lord.
Item number?
Item number 22, my lord. My lord, that affidavit will be called for.
Praise the Lord. My lord, I pray some accommodation, my lord, in respect of item number 61. My lord, your lordship may have it at 2, my lord, if it is not internal.
Why?
My lord, some other, my lord, difficulties there.
Huh?
Some medical appointment is there, my.
So don't forget about it. Last time also I gave you.
Yes, yes.
So
Yes.
don't expect every time I'll give you.
Yes, I'm sorry.
Wait when the matter is big.
Yes.
Don't.
Yes.
Once I have given you doesn't mean that every time I'll
Yes,
give.
yes.
Item number 62, pastoral affair.
So the status report has been already the statement signature of the petitioner has been taken.
Yes, you are the officer in charge or the investigating officer. Why haven't you taken the specimen signature of the person, the petitioner, in spite of their specific orders being passed by this court earlier?
signature লোৱা হ'ল sir.
হা?
লোৱা হ'ল।
ইমান দিন লাগিছিল কিয়?
Sir, মই
এবাৰ অৰ্ডাৰ এটা দিয়াৰ পিছতো নুশুনে কিয়?
নৱেম্বৰৰ 23 তাৰিখে
মই নৱেম্বৰ আগতে অৰ্ডাৰ দিয়া আছে। তেতিয়া মই অৰ্ডাৰ দিছো। 24/11
Sir, মই
24/11 পিছতো আপোনাৰ স্পেচিফিক চিগনেচাৰ লগতে কি প্ৰব্লেম?
sir, মই নৱেম্বৰৰ 23 তাৰিখে কেছ মই পাইছো।
তাৰপিছত
তাৰ-
মই অৰ্ডাৰ দিছো 24 তাৰিখ। 24 তাৰিখৰ পিছতহে কৈছে পিটিশনাৰ। তেতিয়াহ'লে?
তাৰপিছত ডিচেম্বৰৰ 27 তাৰিখৰ পৰা মোৰ আপোনাৰ খানাপাৰা ক্ষেত্ৰত
The investigating officer is in such state of affairs.
But,
If a person is being given for VIP duty, that means the investigation of all the cases which have been given is no longer important.
no.
Then?
That is that. It's on one occasion I have to ask it. On one occasion it might be it. But because of the record was in the Malkhana, because of that, ultimately on the next day, yes.
No, whenever on one hand, he is giving a report before this court that on account of the specimen signature couldn't be taken from the petitioner, he is not in a position to go ahead with the investigation. Now, when I ask this court, I ask the petitioner to go there, he does not take
But now,
serious dereliction of duty.
now it is. And that part.
পঠিয়ালে নাই?
Sir.
Specimen signature to পঠিয়ালে নাই? FSL ত?
হোৱা নাই আপোনাৰ 4 জনৰ আৰু 3 জনৰ হ'ব পাৰে।
আপোনালোকৰ লাষ্ট ৰিপৰ্টৰ মতে পিটিশনাৰৰ ৰিপৰ্ট পিটিশনৰ সেইটো কৰিব পৰা নাই। আপুনি
বাকী sir,
on this particular date, the information which was given is investigating with on course of event, it was found that so-and-so made false signature of the false document and so-and subsequently got anticipated. The remaining case, the case remains pending for obtaining signature of Zakir Hussain and to send the same with the documents to FSL for verification. This is the report which was submitted before this court on 23/11/2023. আৰু কোপা আৰু 3জন মানুহ কোপা আহিলে?
sir, এখন অথৰিটি আছিলে আপোনাৰ লোন এগ্ৰিমেন্ট
আপোনালোকে যোনটো এইটো ৰিপৰ্ট দিছে অফিচাৰ ইনচাৰ্জ অফ দিছপুৰ পুলিচ ষ্টেচন, আপুনি অফিচাৰ ইনচাৰ্জ হয় নি?
হয়।
তেতিয়াহ'লে তাৰমানে তেখেতে ভুলকে দিছে এইটো। ইয়াতো খালি এজন মানুহৰ কথা কৈছে। Have you seen the report?
I have.
It only says about one person. That's the petitioner. Now, where does the another 3 persons come in?
I have the accused person, their signature is also required to make the company. They have to send all the signatures there. They have already.
But the
issued
question is as to whether he has asked those accused persons to come.
Yes, notice has been.
When?
Notice has been given to them. Yesterday was the date fixed. Follow the.
Accused person বেলত নাই জানো?
আছে স্যার বেইলটা।
তেতিয়াহ'লে যদি নাই আহা বেইলৰ কণ্ডিশ্যন নহয় জানো? যদি নাহে যদি বেইল কেনচেল হ'ব? আছে নাই?
And information has been
Not to
given that-
cooperate. If he is not cooperating, bail to cancel কৰিব পাৰে?
হয়।
তেতিয়াহ'লে
তেওঁ
যদি আহা নাই তেতিয়াহ'লে নকৰে কিয়?
নটিচ মই সাৰ্ভ কৰিছো।
সেইটো যোৱাকালিহে কৰিছে। কিমান দিন কি কৰা নাই? 23/11 আজি আমি ফেব্ৰুৱাৰী মাহ।
Okay,
পিটিশ্যনাৰ কেতিয়া ল'লে চিগনেচাৰটো?
তাৰপিছত 8 তাৰিখে লয়। 8 ফেব্ৰুৱাৰী।
নেক্সট আপডেট কেতিয়া পাম?
Within one
Huh?
week.
Pursuant to the order passed by this court on 5/2/2024, the investigating officer of Dispute PS case number 1187 of 2015 is present before this court. It has been submitted that on 8/2/2024, the investigating officer had taken the specimen signature of the petitioner. However, the same is yet to be sent to the FSL. In as much as there is a requirement of taking the specimen signature of the other accused persons to whom notices have been issued. But however, the state accused have not appeared. The investigating officer, Mr. Rishikesh so and so, submits that within a week, he would take the specimen signature of the other accused person and send the same to the FSL. List the matter again on 11th of March 2024 on an update. The personal appearance of the investigating officer is dispensed with. Next, 11 তারিখে আছে update দিয়ে দিব 2 kilo.
Item 60, supplementarily.
Yes, madam.
Yes.
You have a case?
Yes, my lord, I have a case because I am aggrieved by this order dated 28/12,
What
by
did it
which
say?
this person has been appointed, Lord.
28/12.
Yes, Lord. At page,
Where it has become necessary to have one officer in the office. Exercise of- So, why are you agree?
my lord, this order has not alone invalidated the powers of the MD, but also the elected board of directors. This
No,
person,
that election which was held was without a quorum,
my lord, on 16/11, the election was held,
but that is without a quorum.
and in that the board of directors were elected.
But madam, that is without a quorum. There
Yes,
is no
sir.
election at all.
It was without the quorum, rightly, lordship, because the list of shareholders contain the names of those persons, mostly deceased shareholders and persons.
Are
who
you
were out-
saying how many people were present? 10%.
Lordship, 10% couldn't be present.
How many persons were present on that 16/11? There is the minute.
Lordship, at page 74,
20% were present.
1571,
Are the
number.
total members.
Yes.
That-
Only 74 had voting rights, because most of them were either deceased shareholders or.
No. Only 74 members having voting rights were present.
Yes, Lordship.
There were not only 74 members. The total is only 74 members of the having voting rights were present.
Yes, my lord.
Where is the question of interfering?
Because, my lord, this bank has the expertise and the corporate, it is not that the corporation department can run the show, because they
No,
do not
they
have
cannot
that
run the show, but if you can't hold an election, nothing can be done. Let them go and complete it. This court can only direct them to complete this within this period of another 3 months. How much time is there? Another by 28/3. Yes, Mr. Taluka, you'll hold it within 28/3. Nothing remains.
But, my lord, the list of shareholders must be taken care of, because they cannot,
Understood. The list of shareholders, he's the officer who is now in charge to take care of.
they cannot just arbitrarily put in the names of deceased shareholders and those who are staying outside the jurisdiction of the bank.
If it is outside the jurisdiction of the bank, does he cease to be a shareholder, madam?
Oh, my lord.
Does he cease to be a shareholder as per the Cooperative Societies Act? No. A shareholder is a shareholder. Yes, a deceased shareholder, the question is different. But otherwise, and as per you, how many shareholders are alive out of 1571?
Given the figure. That part I'll have to obtain instruction. Only 13 nominations came to be accepted.
No.
Against
What about the
vacancy of
nomination?
15
As per you,
Yes,
how
sir.
many shareholders are there
That part I'll have to obtain.
out of the, after taking into account the deceased? By not taking into account the We'll have it on 17th.
Lordship, but this, your lordship has to give a categorical direction that
That I will consider. As of now, this is a case of not issuing a direction. This is a case of dismissal in limine.
And my lord, secondly, lordship, the bank is incurring a loss.
Huh?
This bank is incurring a loss because of this person. Lordship, around 7
Whatever may be, it
16
is a
lakh.
cooperative bank. It has to follow as per the Cooperative Act. If any problem is there with the bank, all of you can very well vote out there in a general election and have this amended, whatever you do. But as of now, till the Act of 2007 remains as it is, it has to be followed. The law, it is happens, that is not on trial out. And help you. Give you time till 17. Find out how many shareholders are alive. Outside the jurisdiction has no value. It is the shareholders. If a person is dead, it is a different aspect. But if the person is alive, then we can. But we have it on 17 because of the fact that this matter needs to be done urgently.
Yes,
We
sir.
are the time gap given out there is 28-3. So it has to be done. This court had put a pointed query upon Ms. E. Chaudhary, the learned counsel appearing on behalf of the petitioner, as to how many shareholders of the total 1571 are alive in respect to the cooperative society in question. The learned counsel submits that she will obtain the instructions and apprise this court to list the matter on 17/2/2024.
Cooperative bank.
Public. Item number 1, order noted.
Yes, what is it?
Yes, Lordship, in this matter, Lordship, I have filed Wakalatnama on Friday, Lordship. So actually, otherwise also, Lordship, we have taken steps on 2 occasions earlier, Lordship. So we will take steps, Lordship. If your Lordship.
Your case requires to be dismissed on the last occasion. But when on that day, the counsel who was representing the
Yes.
petitioner ought
Yes.
to have been a counsel on the other side.
Yes.
So now I am going to take it on your side. Forget about the respondent. Now satisfy me as to whether you have a case at all.
Actually, Lordship,
What is your case about?
Lordship, actually, my grandfather was holding a property. He was the owner of a property, and he had 6 sons and 1 daughter.
Hmm.
I am the son of the 3rd son, Lordship, who has died, and I am the son of the 3rd son, Lordship.
Hmm.
Now, the wife of the 4th son, in respect of her, a land acquisition case is continuing, and they have prepared at page 18, Lordship will get, they have prepared a final award report, as per which more than
You want certain documents. That's all.
in the land acquisition case.
Yes, you want certain documents,
Certain
nothing more than that.
Yes, sir.
That is your prayer.
In the
Yes, government, who is appearing? You provide her the documents if you have. This is your old case, LA case of 9 of 2013.
Right.
He's asking for the order sheet as well as the award. That's all. And any papers, you can very well take these steps under the RTI Act. Why haven't you done that?
Actually, in the LA case itself, we had filed 1 petition for this document. That petition has not been considered, and it is still pending.
Madam, Mr.
Yes.
Is you can file under RTI. Why you are not filing under RTI and have to approach this court?
His petition.
Does this court resemble you in any manner as an authority or a PIO
No,
of the under the RTI Act?
No.
Yeah. approach under the RTI.
Actually,
And
otherwise,
if you don't get it, then obviously you know what are the avenues available.
yes, but actually,
The learned counsel appearing on behalf of the petitioner. The instant petition has been filed by the petitioner, seeking a direction upon the respondent to provide certified copies of the order sheet to provide the following documents, namely, number one, the order sheet, along with all documents and orders passed in LA case number 9/2013. Number two, award statement issued in favor of Srimati Renu Bora. Number three, newspaper / periodical advertisements in the office of the DC Nogam or any other office affiliated to it in relation to LA case number 9/2013 pending before the ATC Land Acquisition Branch, DC Nogam. Full stop. It is seen from the record, it is seen from a perusal of the relief sought for that these documents, the petitioner can very well avail remedies under the Right to Information Act before the Public Information Officer of the Deputy Commissioner Nogam. So taking into account the above, this court is not inclined to issue a writ in the instant proceeding. However, grants the liberty to the petitioner to avail remedies under the Right to Information Act 2005.
one more thing, Lordship, that case is still pending. LA case is still pending, and this court had on the first occasion protected us that the amount compensation amount may not be disbursed.
You know what to do. How can, with this relief, how can you ask for that? You want this thing, you have to file an application under section 18 or whatever may be. Yep.
Actually, in that particular case itself, Lordship, we had filed one petition.
You know what to do. I need not make the learned counsel clever. If you have any demand or any claim, you are to file an application seeking apportionment or whatever may be. There is provision of section 18. There is a provision of section 12. If it is done under the 64 Act, then you go by under 12 or 10. Or if it is under the 1894 Act, then you go under 18. If it is done under the 2013 Act, then you go under 64. Go there.
For admission item number 2.
Yes, please, your lordship.
Oh, your RTI, that one. Whether they are still.
Yes, your lordship. Lordship, the instruction is awaiting your lordship. So that may be fixed, your lordship. On 15th, the matter can be taken. On 15th.
Right? In 2 days, you are going to get it.
Yes, your lordship.
The 8th Pura Point and the Reserve Bank of India seeks for an accommodation date for the purpose of making the instruction. It's the matter of 17
Item number 3.
In this case, your lordship, the payment has been made, your lordship. It's
Payment made.
referring to the NABARD case, your lordship.
Oh, that one.
Yes, your
Yes.
Got the money?
Oh, yes, I got,
Okay.
but, interest, I'm praying for interest also.
Huh?
Interest.
No. Interest you go before the. You wanted that money you have got it, you should be happy with. The learned counsel, Mr. H. Purapai, the learned counsel appearing on behalf of the NABARD submit that the payment of the amount of 4,63,000 which have been sought for by the petitioner by way of the instant petition has already been disbursed. Mr. K.K. Pupon, the learned counsel appearing on behalf of the petitioner, submits that he have already received the have you the state taking check above the instant look as the receipt which have sought for has been communicate the image the basis of which the learned counsel appearing on behalf of the NABARD has submitted.
Item 4.
Which person? Who is appearing? Who is appearing for the respondent? None appears on behalf of the petitioner. For how is the petitioner agree? Seems the petitioner.
Five.
Oh, yes. Okay, madam.
Yes, Lordship. There is an office note. Lordship.
Yes, respondent who have filed the affidavit.
That is a lot.
Yes. None has appeared on behalf. The record is that on 25,022 earlier said appearing on behalf had duty submitted before the court that the petitioner have already taken back the big chamber and along with the it is under such circumstances this court by the order dated 5/2002 had struck off the names of the earlier count. However, as the petitioner is not put to death, the record further repeats that the petitioner have not appointed any other new counsel. Consequently, it seems that the petitioner is no longer interested in the instance for which the instance is dismissed. Yes,
That is a lot.
I've impeded somebody. What does that mean?
Yadav Kumar. Lordship.
They've taken steps.
Yes,
Lord.
Lord.
I'm appearing on behalf of the respondent for 8 newly impeded respondent.
Oh, very well. You are the owner.
Yes, Your. Yes,
And
Lord.
your behest this happened.
Yes, Lord.
Have you
You
filed your pleading?
No, Your Lordship.
When are you going to file?
Your Lordship,
the whole matter.
2 weeks time maybe can.
Okay, Mr.
K Talukdar.
K. Talukdar.
K.
Mr. K. Talukdar, the learned counsel appearing on behalf of the newly implemented respondent number 8.
Your Lordship, it's the first title of the writ application. The name, the title of the respondent number 8 has been wrongly mentioned. The title of the respondent number 8 has been wrongly mentioned. It should have been Jadav Kumar only. It has been
Jadav
treated
Kumar.
as Jadav Kumar Das. It's only Jadav Kumar.
He writes Jadav Kumar.
Did you file the post?
Yes, ma'am. Amended memo.
I've only said Dr. Jadav Kumar.
In the cost title, Your Lordship.
Where?
Of the writ application.
No, I have asked them to submit a new.
Yes, Your Lordship.
You submitted that post title. Press memo party, did you submit to them?
This part, I was informed by the registry that page 3, if amended, that will do. So
I'm asking you, did you submit the press?
I haven't done that because I was
Then
under,
why should we all take into consideration this? At your behest, we have taken the pains of making the state a party. We strike off his name because you have not complied with, and then dismiss your petition. Very well, we'll do that. The record reveals that this court by the Consolidated
I had given that, may I say something?
wage of more parties.
This
No
is-
memo party.
Lordship, I had,
You have not given the memo party. Madam, without an application, this court had taken the pains of doing it. Then why have you put Jadav Kumar Das? Court had only impeded this. You have given this. No.
yes, Lordship, I had filed it.
When? It is here. Still here. And why have you put Jadav Kumar Das? Finally see, it is Dr. Jadav Kumar. The learned counsel appearing on behalf of the petitioner have not submitted the amended memo of parties as directed by this court on 6/1/2024. He Chaudhary, the learned counsel for the petitioner, seeks for an accommodation of a day for submitting the same. On the other hand, Mr. K. Talukdar appears on behalf of the newly implemented respondent number 8 and seeks for an accommodation for filing the reply. Taking into account the above, this is the matter again on 20/3/2024. The petitioner, counsel for the petitioner, is directed to file the amended memo of parties during the course of the day, failing which the matter be listed before this court on 17/2/2024.
Okay.
Item 6.
Lordship, in this case, Lordship, petitioners filed a FIR for felling trees from his landlordship, but the police has not filed any report in the FIR, but in the non-FIR, Lordship, the police has submitted report to the additional district magistrate. And from that report, it seems to the investigation is complete, but they have till now, till today, Lordship, even after 7 years, Lordship, they have not filed any report as required under 123 charge.
Why don't you go to the land grabbing court? Your land,
Lordship is a shilling surplus land.
so you are possessing,
Yes, Lord.
file a suit, somebody else
But-
is grabbing. Has
That
anybody
land
grabbed
grabbing
or
case
are
is
you in
already
possession?
filed in Hailakandi, Lordship.
Your case is under 379,
Lord,
Chef.
Lord.
427,
Lord.
what is that?
Lordship, criminal trespass to the petitioner's land. And this one is
447. That is criminal trespass.
Yeah.
And for 34. So,
in that affair, Lordship, they have not acted taken any step to file report.
why you are not approaching under 156?
Lordship, petitioner already approached under Land Grabbing Act in Hailakandi Road against that. But here it is a police case.
This is not done under the land grabbing. These are sections nothing to do with land grabbing. Why we are not incorporating section 5 of the land grabbing?
Lordship, after failing of the failing and taking away the trees, Lordship, later on he Lordship captured the land. So against that, Lordship, the petitioner has filed a land grabbing case.
So then, whether
No,
this
but-
FIR has been registered or not.
The affair has been registered,
So
Lordship.
now the question is the investigation has not been done properly.
Lordship, that is the
To go under 156(3), why should this court exercise jurisdiction in view of the categorical judgment of the Supreme Court? Why should this court exercise jurisdiction? And then you see the problem otherwise arises is for this court to monitor becomes very difficult. For a magistrate over which that police station is, the magistrate can very well on periodical basis monitor. That is why the matter of 2016 is coming before this court now. The instant petition has been filed, writ petition has been filed, but taking a direction upon the respondent and more particularly the respondent, who is the officer in charge of Lada district, the district of Hailakandi. Being aggrieved by the inaction, aggrieved by the manner in which the investigation had been carried out in Lala PS case number 70 of the 2016, registered under section 379 of the 47 of the 447 of the 34 of the Indian Penal. This court, upon perusal of the petition, finds it relevant to observe that the petitioner herein is aggrieved by the manner in which the investigation has been carried out. Under such circumstances, it is the opinion of the court that the petitioner would be well advised to proceed under section 156(3) of the Code of Criminal Procedure 1973. Furthermore, in view of the judgment of the Supreme Court in the case of State of UP versus Sakira Basu reported 2008 to SCC 427, it would not, this court, the jurisdiction, the petitioner is therefore required to approach the concerned magistrate having jurisdiction over the police station in question by filing an application under section 156(3) of the code. So taking into account the above, this court is not inclined to issue a writ in the instant proceeding. However, liberty is given to the petitioner to approach the concerned magistrate. So the CGM, the Chief Judicial, the learned Chief Judicial Magistrate, Hailakandi, if the petitioner is aggrieved by the manner in which the investigation has been carried out in Lala PSC.
Obliged.
Item 7.
May it be the Lordship. My Lord, this matter, my Lord, the petitioner before my Lord is the Decoy Town Committee, my Lord. We are here for a very limited issue, my Lord. The Town Committee was allotted a plot of land for starting, my Lord, the solid waste management project for disposal of the garbage, my Lord. So for disposal of, my Lord, garbage to waste of Decoy Town, a plot of land was allotted to them in the year 2011 by the state authorities for starting this solid waste management project, my Lord. Now we are aggrieved by the fact that the department had cancelled that allotment and have not given us any alternative plan for disposing, my lord, the solid waste, my lord. In between,
Posing what?
for disposing, my lord, solid waste
Waste.
of liquid on
So it is your town committee.
yes, my lord. We are the town committee, my lord.
They have not been given the solid
The
place
plot,
where you are going to.
yes, ma'am. We
You
were,
have an act, no? The Solid Waste
Yes.
Management Act. What does it say?
my lord, basically, initially we have been dumping the solid waste in a close vicinity of the town area, which was objected by the locality people, my lord. So we have to alternatively change, and we initiated, my lord, on another plot of land which fell inside a reserve forest. So that
Where
was
we
also,
see the-
my lord. So that was also, my lord.
He has been given alternate land.
My lord, now we have been given a plot of land, my lord. So kindly, my lord, may kindly peruse.
the age should have corrected the The petitioner here is, it is the town committee being agreed by the cancellation of the allotment of land by the respondent authority to dispose their solid waste have approached the court by filing the incident. The learned counsel, Mr. H. Puragoy, submitted that on 19th of March 2020, a plot of land measuring 10 thirds, covered by dark number 77, situated at site number Laida under Pakum Puja of Adheta Revenue Circle, the district of Principia, have been allotted in favor of the municipal board for dumping of garbage. In that regard, on 12th of October 2015, the possession was also handed over to the petitioner. Taking into account the above, the learned counsel for the petitioner therefore submits that nothing further remains in the instance. This court, having taken into account the above, is of the opinion that the instant petition has become infructuous in view of the allotment made on 19/3/2020 and the possession handed over on 12/10/2022. According to the petition, the document is placed before the court as regards the order of allotment dated 19/3/2020 and the order, the certificate of possession dated 12/10/2020 are kept or recorded of the letter are acted.
I'm highly obliged.
Item 8.
Lordship, this is the petition against the judgment award passed by the Labour Court, Dibrugarh, Lordship. The case was the petitioner is that, Lordship, the respondent is not that he was a driver on 30/5/2012 while entering the garden. He rushly drive the school bus and knocked the door as well as a result of which one security was killed.
Yes, what is your case?
Yes, Lordship. Because
You are
the
challenging this award.
site is not. Yes. Then because the respondent was a bus driver, school bus driver of the garden lot. But earlier he was also the same way. Sometimes he's rushed in a very negligent the school bus. And on the day of incident 30/5/2012, noted, he come inside the garden, factory garden, park the vehicle, he rushed in a very negligent manner and does the cause the loss of the factory gate as well as a result with the security guard was killed. Then we initiated
served a notice and charge sheet was prepared, and domestic inquiry, the report of the domestic is page number 28 to 34, Lord, where the allegation was made against him of gross misconduct. Then we are again
Did you say that if the domestic inquiry was not held against you, you are going to exhibit it?
domestic inquiry was in favor of the management law.
Understood.
Yes,
Domestic inquiry was
yes, sir. Against the respondent number 2.
taken as a
Yes,
for the labor court.
Yes.
It was held that the domestic inquiry was invalid.
Yes.
And consequently, the labor court tried anything.
Yes.
And overturned the dismissal.
Yes.
Did you say that you are going to introduce evidence if your domestic inquiry goes against you? Held against
in that part also, regarding the evidence also, because this earlier also in 2 occasions we complained because this is a school bus. Parents did not allow such a person who dropped the vehicle because earlier that thing has happened. Lordship.
domestic inquiry. They decide the
Yes, sir.
it upset.
Yes, sir.
I know put it on the basis that the domestic inquiry not have been done. Or are you also
Lordship. The thing is that in my submission part only the very Lordship.
say I have expressed something that
No, Lordship.
that
The issue number 2 part, Lordship. The issue number 2, which has been decided that
I'm
is-
the court,
yes, Lordship.
what does the court say? Look here, the domestic inquiry was in the basis of this.
Yes, Lordship.
I therefore it to debate your evidence on the domestic inquiry set aside.
Yes. No. On that context, Lordship, before the learned labor court also.
If you want to go for this, go into the fact.
Yes.
Not go into the facts because those facts are not before the labor. The labor court had totally decided on the question of the domestic and said that the domestic inquiry was valid and consequential action was being taken.
That only, yes.
So
that only.
therefore, what is normally done for a labor court is you raise the particular objection and start the first side the question of 50-minute judgment. And thereupon also say that if the case of domestic inquiry is valid, I may give it the bit. But that then how can I
Like-
fix the merit?
Learned court, before the labor court, the evidence part but that issue actually in the family. That I now I got that part is because evidence was reduced before the labor court also. Everything
There
was,
was evidence in the labor court
yes, Lordship.
and the labor court did not fix that.
No, Lordship.
Did it?
Labor
So
court,
make
because
that
that I have an enclosed also. I have an ex also,
To
Lordship.
make that submission that the labor court was taken apart, but labor court was also the
Yes,
labor court
Yes, sir. That labor court has-
mainly on the ground that the domestic inquiry was made?
Oh, no, no. Then that labor has approached before the labor commissioner, that is in lordship, and by filing a petition that against the termination he challenged before page number 40, lordship. They filed an application. Initially filed an application, page number 40. Page number 40, the application for conciliation that was failed, and later on, lordship, page number 44. Page number 44. That was registered as ID case number 5/2013.
Yes, madam. Here, there was evidence.
There was evidence.
Then why the labor court only decided on the basis of that? What the inquiry report? The inquiry report was okay, bad. But wasn't it required for the labor court to look into these aspects?
No, I will take your lordship to the award. I will take your lordship to the award.
Yes, what does it say?
It considered all the evidence.
All the things is different, but the thing is, what has been done is out here. The entire basis on which the entire the argument, then the cross, 2 years with the domestic, and he has all based his entire decision on the domestic inquiry. Nothing else.
Domestic
He
and
should have decided on the case on the basis of the facts and held it. Why the labor court didn't look it over?
that finding is there. And my lord, what happens, my lord, here criminal case was filed against the workman, my lord. And in the criminal case, he was acquitted.
So,
And
are
and
you
my
saying
lord,
that the
no,
facts were totally
uh,
disproved?
no, my lord, here what happened? The same set of evidence, before labor court and also before domestic inquiry. Same set of evidence.
Madam, you see, kindly see a recent judgment of the Supreme Court in the case of Ramlal. Got that?
Another.
Ramlal.
Yes, my lord, I'm taking
that
this
one.
position, madam.
Now, in that judgment, the Supreme Court say, yes, same set of facts that all things are there. But from the materials on record has to show, or the findings of the criminal court was such that the facts were totally disproved.
Here not disputed. And the same set of here, my lord. I will take your lordship to clause C. Here it says, my lord. Reiterate that mere acquittal in criminal proceeding does not confer any right to the employee to claim benefit, including reinstatement. However, where charges in departmental inquiry and in criminal court are identical, here charges are identical. And evidence, witnesses, and circumstances are also same. Here, evidence also same. And where the court in exercise of judicial review finds that acquittal in criminal proceeding was after full consideration of prosecution evidence, and prosecution miserably failed to prove charges. Court can interfere with order passed by disciplinary authority where finding of disciplinary authority are found to be unjust, unfair, and outrage. Each case depends on its own fact. Here, my lord,
Up to date,
another paragraph, C.
It categorically says the facts disproved. It's 2024 1 SEC, na?
24, 175.
The
Here, my
judgment,
lord, I will take your lordship to
can you show me the judgment? Hey,
your lordship has looked to clause C also.
I have to
It squarely covers my case.
understood, but there is another aspect of that. We are satisfied that the findings of the appellate judge in the criminal case clearly indicate that the charges against the appellant was not just not proved. In fact, the charge even to disprove by the very prosecution evidence. As held by this court, a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man or under the circumstances of the particular case act upon the supposition that it does not exist. In this case, what has happened in Ramla, this person concerned in a drunken state so informed the other person concerned that look here, I had taken the government for a right. My date of birth is actually in the year 1972, but I have stayed it to 74. And then an inquiry was held on the basis thereof, and action was taken against, and it was the person concerned was very well terminated on the basis thereof. Then, in the criminal proceeding, Exhibit 3 was the document, which was his birth certificate, was taken note of. And the birth certificate categorically showed that it was in 1972 he was born, not on 74. And as such, the criminal proceedings were not only dropped, it was categorically observed by the appellate court to that effect that it is a case where there is no evidence at all. So it is under that circumstances, paragraph number 29, the Supreme Court therefore says, yes, in a criminal and a civil proceedings or any departmental proceedings, it is not necessary that an exoneration in a criminal proceedings would lead to. But if it is a case where the fact is disproved, because here there are many judgments of the Supreme Court which categorically say, after this also, many judgments which say that where exoneration in a criminal proceeding not to exoneration or the punishment being exonerated in a disciplinary proceeding. However, the Supreme Court here called out the principle that if it is a fact which is totally disproved, which disproved means it is not in existence or the word is so probable that a prudent man or under the structure of a particular case act upon the supposition does not exist. It is under that circumstances. But the fact remains out here. In this case, the labor court did not look into it.
I will take your lordship.
There was the evidence out there. Labor court should have looked into it.
I will take your lordship the fact if your lordship permits me.
Okay, we'll have it on some other day. In the meantime, let him go. I should not be arguing on his behalf. He doesn't know. Don't tell him. Yeah. The request of the letter, taking into account the instant proceeding, we take to challenge to an award passed by the learned labor court, and the records have been duly received. It's the matter for this court duly admits the instant petition and fixes the matter for hearing on 12th of March. 12th of March.
Item 9.
Telling a cancellation order and cancellation of work order.
I've asked you to obtain some instructions.
Lordship, I tried to contact the petitioner yesterday also, Lordship, but he did not respond my phone call also.
Huh?
He did not respond my phone call also, Lord. By the
He doesn't want anything to do with you. What is this order?
Lordship, this is a cancellation of the work order, Lordship. The Lordship will find that page
of the meeting
20,
for
Lord.
package. That's it. About 70. Where's that order?
Lordship will find it at page 20 of my registration, Lord.
Page
20, Lord, 20. And
Is it to inform that due to
Thereafter, Lordship, I have no,
candidate to work order providing it.
the work order, Lordship, will find it.
Who are you?
I'm
who
the
are you?
contractor, Lord.
Then how are you agreed?
Lordship, without any reason, Lordship, cancel the work order issued in my favor, Lord.
That has been cancelled.
Lordship,
Doesn't
Lordship
say
will find it the annexure 2, Lordship. That is the work order, Lord.
that during the inspection of stock of materials as per the cash payment was the site. It put up particular for the additional facility of the supply.
Lordship, the state work order, Lordship, proceeded with the contract offer. And Lordship will find
No,
the
here, therefore I said on the last occasion that this affidavit in opposition was very damaging for you.
Lordship.
And then if you don't file a reply, nothing can happen. For which I had given you an additional opportunity on the last occasion. You failed to take it. Now he is not bothered. Here, what has happened? You are asking about the additional quantity.
Right.
Now here, their specific stand is the additional quantity. You have not done any work. So what is your right?
Lordship, the allegation, Lordship, that he had not executed the earlier work, Lordship, as per the plan.
Earlier work is,
Right.
they say,
Right.
these photographs which are there,
Right.
categorically say about the earlier work order,
Sure.
but nothing to do with the additional quantity. This is what their submission is.
This photograph, Lordship, additional
No, no.
facilities, Lordship. Photograph,
Therefore,
Lordship, Lordship will
therefore,
find it the
if
page
that
16,
is so,
Lordship.
then I think the better of you go before the trial court.
Lord.
The only way out is to go before the trial court.
Lord.
The instant petition has been filed by the petitioner, seeking a direction from this, read from this court for setting aside and quashing the order dated 23/6/2017, and also a direction to the effect directing the petition respondents to allow the petitioner to complete the work as per the work order dated 23/6/2017. Same date.
Same date, Lord. That is the date.
From a
That-
perusal of the materials on record, it reveals that on 23/6/2017, the Divisional Forest Officer, Kamrup West Division, had issued a letter of acceptance come notice to proceed with the work for utilization of surplus amount for providing additional facilities in the forest guard quarter at Kantipur under Bamunigaon package number FIU/KW/TW/2. The total amount as per the said communication was rupees 2,69,099. It has been stated in the petition that the petitioner had purchased certain materials on the basis of the said work order issued, which have been enclosed to the petition as annexure 3 and 4. Further to that, it has also been mentioned that certain works were duly carried out, and to evidence the same, photographs have been enclosed as annexure 5 to the petition. However, on the very day, that is on 23/6/2017, when the work order was issued, the Divisional Forest Officer West Kamrup West Division had cancelled the very work order. And it is under such circumstances that cancellation of the work order on 23/6/2017 have been assailed before this court and seeking for the direct as already stated herein above. The record reveals that an affidavit in opposition was filed by the respondent number 3, stating inter alia that on 23/6/2017, the work order was issued in favor of the prisoner, and he was asked to complete the work by 30/6/2017. However, after issuance of the work order, it was the authorities concerned took into account that in the previous work which was awarded to the petitioner, there was a delay on the part of the petitioner to complete the same. And under such circumstances, on the very date of issuance of the work order was cancelled. It was also mentioned that the cash memos which have been enclosed to the writ petition to the effect to show that the petitioner had purchased the materials in question are irrelevant, taking into account that during inspection, no stock of materials as per the cash memo was seen in the site. Further to that, it was mentioned that the photograph furnished by the petitioner was for the works done against the estimate of the existing building and not the additional facility of the water supply as claimed by the petitioner. It was therefore stated that the photographs submitted by the petitioner are not genuine. This court have also taken into consideration that the said affidavit in opposition was filed on 7/11/2017, but till date there has been no reply. Under such circumstances, it has to be presumed that either the petitioner duly accepts to the statements made in the affidavit in opposition, or the claim of the petitioner is seriously disputed. Considering the above, this court finds no ground to interfere with the instant order, with the impugned order of cancellation, impugned order dated 23/6/2017, whereby the work order of the same date was cancelled. Accordingly, the writ petition, in that view of the matter, the writ petition therefore stands dismissed. Be that as it may, if the petitioner is otherwise aggrieved, the petitioner would be at liberty to approach the appropriate forum wherein factual adjudication can be carried out. carried out without prejudice to the observations made in the instant proceeding, without prejudice to the dismissal of the instant petition. This court, however, further
Public.
take the court.
We have seen the communication, my lord, sent to my lord last order. So we are awaiting the instructions. But here,
I have asked the finance department to apply for whether the hearing to be invited to the office.
apparently not, because that office memorandum, of course, I do not have a copy. I apologize for it, my lord, because that is with regard to my lord counter insurgency operation.
That is why I
Yes, yes. Now the opening words of that poem and notification, my lord, makes it very categorical. That my
so
lord,
there they did
my lord,
it
my
29 like
my lord.
this 29th of July of
Because my lord,
no, here it is. It is to order that the family of state of Munda, person of army, central street, gate, third,
Yes.
in the state.
Yes.
If it fight
Yes.
or in connection with the charge of
Yes.
as also the family of right by or of the state of to leverage
Yes, now, my lord, the intent of the notification itself was to show, my lord, that it is with regard to counter insurgency operations. Now, my lord, in many situations, you may be aware, my lord, that
but there are three, not one. One is either extremist or counter insurgency. Number that is attack of socialism.
Yes.
Number three, for that you could address
yes, now here is a case, my lord, where the petitioner went missing. Admittedly, my lord, he was not on government. It is not the case of the petitioner that he was on government duty. He was asked to went to a particular place. He was, my lord, on duty, and then he went missing. It is not the case out here. Therefore, lordship will kindly see, my lord, this is the second repetition. Repeat, my lord, yes. With regard to, my lord, that finance, my lord, notification. Yes. Now, here, for a moment, it might, no, my lord, lordship, an SRP of the repetition. No, but I am
I'm not going to file an here entitled because so then we hold yes.
so that is
So there it can't pick it to us.
lordship is correct. My lord, notification.
If
But
Our officer is already come to the
Lord,
period.
would kindly
Finance
consider
not completed. That the notification, the office member dated 29/7/2006, yeah, if a offense other like death is expected or after this topic or on account of death with check of future relief or an account of death to celebrate it, but not for hard to dispose because of the such type of finance not take by way of an act defined of finance. It's the matter again on 11th of March 2004, the F55.
I'm deeply aware.
and so, because otherwise, my lord, what I was submitting, with all respect, so it is not the case of the petitioner is well, because that he is the one.
No. He was rejected on the ground that he is the government employee.
Government employee.
Government employee it has done because he is otherwise as per the deadline, as per each. That is the stand of the petition. Now it come up, then we hold it that that notification government employee there
My, my,
Right.
my, 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 my,
to
my,
develop once they file that application to develop your case.
Okay. I'm
11,
deeply aware.
apply for it.
Yes,
The last date also learned council for the GMC did not have. GMD, Mr. Bora.
hello, we call the KMT commissioner as for the transportation. The case. Taking into account that the council for the game is not presented on 29/1/2004 as well as also today, and thereby the same is impeded upon the they be impeded in the disposal of the intent. This court, therefore, the matter on 11th of March 2020, on which day the commissioner James shall be personally present to the video to be provided by the standing council of the game at 10 a.m.
Lovely.
It however observed that the circumstance the council is represented the presence of the game
12,
represented
12 to 14,
yes, but it is two cases same.
What do you think about the point about four?
Yes, what it is.
So, we are the petty businessmen running our business at Colton Bazaar Municipal Market area. And on 23rd October 2017, there is an order from the commissioner for demolishing our, removing our shop for shifting of that temple. Against that, we moved before this honorable court, and the honorable has directed that there is pendency of the case will not be a part for reconfirmation of the area, and also to give opportunity of hearing before enforcing that order. But that was not done. Instead, they are issuing a show cause why we should not be evicted from the place. And then we communicated the honorable court order that no personal hearing has been given to us. But instead, they will not demolish our shop. Against that, we move this application.
The second
Report. And there is also continuous pending for violation of that court order. CMC is there as Bora is supposed to appear.
affidavit filed,
affidavit filed.
it says
They said, my lord, for complying the decree, they have to keep, but why they have particularly selected this four top, they have not disclosed that. That is why the honorable court has directed them to give the personal hearing. And there is a detailed order in.
no. What is it? What the first with 17? Is that it?
Yes, my lord, it's at page 74, my lord. 72, start down below, my lord.
So what's your right to meet of the
But we have that license, my lord, without giving opportunity, they have,
what license?
we have been allowed by the GMC to run the, my lord, the business there in the Procedural market municipal. There is no dispute, my lord.
Huh?
There is no, we have not enclosed, but there is no
Well-
dispute to that, my lord.
Then what right do you have?
That without giving,
Merely having a trade license, they allowed you to work at
I mean, we are running for last 30 years. We are paying the
you run for
rent.
100 years, doesn't give you a right.
No.
You don't have an identified stage where you are.
We have been given allotted shop, my lord.
Where?
We have,
Show me that.
I have stated in.
No. It's the whole matter. Why have it provided any applicable to the effect, bringing on record that you have been allotted a particular stage? And how can there be allotment for years? It's not perpetual.
They have collected the rent, my lord. There is no,
Even they have collected the rent. Therefore, they can wait by the week if you pursue to orders passed by the court.
that's why
What right you have to be? Your document does not say that you have a right.
then in that case, because I am craving leave at that time.
Why did you crave all twice from 2007 October till now?
Because at that time on 23 October, they have moved, my lord, issued this order. Against that, we have moved before this honorable court. On 8/11, that honorable court has passed the order. Lordship can look into that order.
I'm not going to look into it. First, you have to satisfy what is your right. You don't have a right. Wherever other aspects are concerned with what the document.
No,
I'm only concerned about what they you have to have a right.
yes, my lord.
Because there are other litigations that are going on in a civil court.
Yes.
There is an execution proceeding.
Yes.
You have gone into a CRP.
No.
Somebody has gone into
My lord.
CRP. The CRP also, there is a direction by the court, identify that particular land, and then move them
My lord.
and you are carrying on the business. On what basis? Where is
No.
the document so that you have been permitted by the state to carry on?
Then lordship will, any that week I will brought on record, my lord.
2 o'clock.
Today.
2 o'clock, show me what's your right.
My lord.
Not have a right.
No, we are not an enforcer, my lord.
Are an enforcer.
We have been allotted, my lord. There is,
Where is the allotment?
that will,
Why haven't you include all these five? What right do you have? Yes, Sahib. What right do they have?
Lordship, here mere license. Here mere license here. No
What is
allot,
like this?
mere license.
Of?
GMC under this here. As per
Game
the,
been paid like
Lordship,
It is a trade license or what?
tradeless,
Nothing more.
nothing more, your lordship, and as per the decree, your honor, lordship, 4 lessons of land is to be identified, your lordship, from this decree, as per the decree. And in that 4 lessons of land, there are some shopkeepers. I don't think that they are the shopkeepers in that area. That has been identified. There's 4 lessons of land for shifting the temple, your lordship, in the decretal land. There is a temple in the midst of the decretal land.
Who has got the key?
Decree, your lordship, landlord has obtained the decree, your lordship. That is,
How can there be a direction or there can be an allotment made by the same
no,
in the land of somebody else?
no, allotment.
But then,
This is a
and GMC is not represented, so
This is
GMC is not going to help.
when the
Well,
matter, and already a
This is
decree,
not
decree has been executed also, your lord.
Huh?
Decree has been executed.
They've been thrown out. It was still
Yeah, they are not there now. They are somewhere else in this same market, your lordship, but somewhere else. They have been accommodated somewhere else. Nothing.
Therefore, there is no document we have taken. And if you have stated that the GMC had granted allotment in respect to their land, show me that statement.
They have filed a.
No. Show me that statement that the GMC had allotted land or a house wherein you can carry on that business. Show me. Forget about the trade license. Trade license, show me that. Where is the state?
They have not filed any.
No, you have stated out here, no? You said just now. Where?
Paragraph
The
2,
GMC has allotted a area. Where?
statement is paragraph 3, my lord.
Huh? Where?
Paragraph 3, my lord.
Where? Paragraph 3 of which petition?
Well, first one, item 12,
6675.
my lord.
Yes, what is it?
No, not 665, my lord. 2650, my lord. The first one,
That is second one.
item 12,
That is second one. Yes. Paragraph 3.
my lord. The petitioner, petty businessman earning their livelihood by means of running small shop situated
Show me paragraph
page 5, my lord.
the petty business and the livelihood of the crop. So, it is expired. The it is where's the license? Yes, paragraph number 4 of the affidavit filed by the respondent.
My lord.
DMC categorically denied that any allotment was made in your name. And this affidavit was filed as far back as of 2018. We are in 2024. 6 years have passed by, you did not file any reply. Now therefore, I think this is a fit case wherein this court should exercise jurisdiction and calling for the presence of the person concerned for filing it, and if not, putting him under 340 behind the. Then we will consider this. Yes, GMC, what do you have to say? Was that the municipal market? Huh? You have default.
That process is going on. Right, at the civil court also the litigation is going on. Ultimately, the civil court so decided that Kalimonde will be shifted. That will be given, that coastal land has a subsequent law. And that also as of today, whether the Kalimonde has shifted.
I'm not concerned about Parliament. Whether the petitioners herein were granted allotment by the judiciary.
It is not.
Huh?
It is granted.
Allotment. Then,
Where the
then why are you saying in paragraph number here that we to call this demo betray yes? That with regard to the answer there stated no data has been placed, no document has been placed on record by the so that clause number 17 was adopted in the purpose as such the petition put to the strictest proof. Then what you are submitting is contrary to what has been given in the affidavit.
that's very good.
Then?
That's very good. You allow me some time to get to the affidavit, my
2
lord.
o'clock.
Got it. Go.
Okay.
Item 15.
Yeah, please, the lord. Lord, in this matter, I'm led by senior counsel, Mr. Kane, so
Can I help you?
he's on legs. I may start. The matter pertains to allocation of rooms in the Pamohi fruit and vegetable market, madam. There are total 21 petitioners here in madam. They were the members of the Guwahati Hakpasoli Bebohai Honsta who were operating in the wholesale market from 1995, madam. Till they were evicted from that market in the year 2008 by virtue of an order which was passed in a writ petition 8081 of 2005. Thereafter, some of the wholesalers, they've approached the Honorable Apex Court. The Honorable Apex Court passed an order on 29/8/2011, which is at page number 37, my lord. Now, by that order, the Honorable Apex Court directed the respondents to reallocate them in the periphery of Guwahati in the new market that has been constructed, my lord, within a period of 1 year. My lord.
But application
Thereafter, my lord, when this exercise was not conducted within a period of 1 year, some of the members, some of the petitioners, they had filed a contempt petition before the Honorable Apex Court. During that contempt petition, the contemners had filed an affidavit. Now, in an affidavit, which is at page number 47, they have filed a letter where they have stated that a provisional allotment list they have drafted. And in that provisional allotment list, the name of the petitioners were there. And these petitioners were found to be genuine, my lord. This letter is at the type copy is at page number 47, my lord. And the original is at page number 49. We were in the lot of 90 numbers, man. And the list is there from page number 50 onwards.
Yeah.
All the names of the petitioners are there, man. 21 names of the petitioners are there.
Yeah.
Then they were allocated, provisional allotment was conducted, my lord. Then they were allocated rooms in the ground floor, first floor, and second floor. My lord. That was done. Thereafter, that allotment was cancelled, my lord. There was a letter, and by that letter, that allotment was cancelled. The collector of the Guwahati Municipal Corporation requested the secretary. Now pay, which is page number 66, my lord. My lord, they were cancelled.
This is the
Page number
26, 13 to 25. The documents required. Documents required to verify that whether they are genuine or not. They doing the business in Moscow of that particular time.
These documents were sought for, my lord. We could not submit some of the documents, my lord. Some we had already submitted, my lord. Thereafter, the allotment was cancelled, my lord. Thereafter, the Honorable Appellate Court has cancellation. Page number 7. My lord, page number 71, there's an order, my lord. Order dated 25/2/2015.
Yes, the second one is the order where it was clearly stated that the documents required was state license of GMC, license under Assam State Regulation Marketing Act 1972, any other proof of doing wholesale business, Moscow.
Then we were not allotted the rooms, my lord. Thereafter, we had come before this honorable court.
113. 35 was found to be genuine, 78 not.
My lord.
And you fall within the 70.
My lord. Yes, according to them, my lord. Then we had approached this honorable court via writ petition, my lord. That writ petition was finally disposed of by 9/2/2017 order, which is at page number 76, my lord. It's an important order, my lord. This honorable court directed Respondent to conduct a de novo exercise, my lord. The operative portion is at page 81. The honorable court directed them to conduct a de novo exercise and give us a preferential treatment. Lord. They were asked to circulate the guidelines, and on receipt of the guidelines, we were asked to apply fresh. Lord. Then they didn't circulate the guidelines. Well, they did widely circulate the guidelines. They only provided to the respond number 1, my lord. Thereafter, we have filed this present writ petition before this honorable court. Now, this honorable this court had, by an order, has asked them to issue guidelines fresh, my lord. And thereafter, they have circulated the guidelines, and thereafter, we have applied fresh.
Where there is an order. 14/6/2016.
I'm sorry, my lord, I was little late.
There is a
Yes. 14/6. Yes, 14/6 order is at, my lord, page number 87. My lord, basically what we would like to say, my lord. My lord. No, basically no, my lord, during the pendency of the case, many development have taken place, my lord, which we have brought on record by filing additional affidavit. My lord, earlier when the municipal corporation undertook an exercise, they found us to be, my lord, the genuine party, having been, evicted from that old market. Now, my lord, pursuant to the Supreme Court's order and this Honorable Court's order, they have constituted a committee which is again not in terms of the Honorable Supreme Court's order. Yes, yes. If your lordship will kindly come to the Supreme Court's order, that order lordship will find.
Page number. Yes, page 45, my lord.
Page 45, paragraph.
Yes. If the markets are not constructed yet, they will be constructed by the government, the municipalities and other authorities in consultation with the representatives of the wholesale traders of Guwahati, and allotments made within a period of 1 year from today. For the purpose, a committee shall be set up under chairmanship of the concerned Secretary of the Government of Assam, and having members from the representatives of the Guwahati municipality and other authorities, and also representatives of the Association of the Wholesalers of Fruits and Vegetables and Grains, etc., as well as representative from the Electricity Department, Water Department, Telecom Department, and Police, etc. This committee shall form a rational plan for allotment of the existing wholesale market inside Guwahati city to new wholesale market if it has already not been constructed. As all the wholesalers inside the Guwahati city shall be allowed to apply for allotment of adequate land for the wholesale market at the outskirts or beyond Guwahati city. If such applications are made, same will be decided by in a fair and non-arbitrary manner without any pick and choose basis. The entire exercise, including allotment, must be completed within 1 year from today. Well, from time to time, they undertook some exercise, but the fact of the matter is, yes, Michael. My lord, police and all these are not there, my lord. No, my lord. Now this is not the decision. Now this is substituted by other decision. That lordships will get.
So around 14,018,
Yes, subsequently not, my lord. My lord, on 28/3, they have filed an affidavit where they have annexed them. I think, my lord, the running page would be Marketing Board, my lord, page 167. Page 171 is the committee. Now this is the final order, my lord. Before that, if your lordship will kindly come to page 167, my lord. Guidelines for allotment of shops to eligible wholesalers in the fruit and vegetable wholesale market at Pamohi under Guwahati Sub-Divisional Market Committee. The committee, constituted by government notification dated in its meeting, formulated the following guideline for free and fair allotment of shop rooms in fruit and vegetable wholesale market at Pamohi, in pursuance of the order dated so-and-so of the Honorable Supreme Court, passed in so-and-so, including order dated 9/2/17 of the Honorable Guwahati High Court, passed in 1/8/5/15, and other order dated passed in WPC number so-and-so. The shops at Pamohi market will be considered for allotment to eligible wholesalers from the following. Those who have been doing their business at Pamohi Gorsuk market, including the writ petitioners, so-and-so. In my humble submission, my lord, this class of people are not before the Honorable Supreme Court, so their consideration does not arise. B, we are covered by B. Those who are doing business at Maskwa before their eviction by concerned authority in their 2005, including writ petitioners of WPC, so we were the petitioners. Now, what are the, my lord, the criteria? Please come to 4. The prescribed application form should invariably be accompanied with the following document. In case of wholesale falling within category 1A above, we are not 1A, my lord. Kindly come to 5, my lord. Next page at 168. For both categories of wholesalers, that is category 1 and B, 1B above, the following documents for KYC requirement must be furnished with prescribed application form. 3 copies of the recent passport size photograph. 1 photograph should be pasted in the given place, a space, and remaining 2 photographs should be securely attached with the application. Photo identity card, that is PAN or Aadhaar card. proof of address, that is either passport, Aadhaar, etc., driving license. In addition to above, both categories of wholesalers, 1A and 1B, must furnish undertaking by affidavit to the effect they will abide by decision taken or to be taken or procedure to be adopted by the committee constituted by government notification dated so and so in the matter of allotment of shop room. They have not holding, occupy, utilize any shop rooms under GMC. They will enter into an agreement with the Guwahati Subdivisional Market Committee. They will pay monthly rent, shop user charges timely to the Subdivisional Committee. They will deposit the adequate security money to the Guwahati Subdivisional Committee. We all fulfill these conditions, my lord. Now kindly come to page number 171, my lord. See the committee.
These are members present, not the committee. These are members who
No,
are
minutes
present.
of the meeting.
There might be a meeting which have the quorum has to be there.
No, my lord.
It is only required when everybody is required to be present.
All right, my lord. Supposing we're not being technical about the constitution of the committee.
The
My lord-
committee has been constituted in 2012.
12.
The committee remains as it is.
Ah.
There is no change to the committee. The committee remains as it is. Maybe on a particular meeting, all the members may not
be present. Possible. No, my lord. Assuming we are prepared to, withdraw our challenge to that aspect. But my lord, we were found eligible earlier. And this honorable court there is an order also of this honorable court, whereby, my lord, our stand was accepted. Now, all of a sudden, how come, my lord, we have become ineligible? And kindly see the
No, when
requirement.
did you become ineligible?
They have not allotted any shop.
No. After these new guidelines have been framed,
Yes.
have you now been found to be ineligible?
No, they were supposed to place the, my lord, outcome of the exercise before this honorable court. In terms of your lordship, order dated.
What happened?
Guidelines are formulated as per guidelines.
If your lordships will kindly have a look at, my lord, page number, it is running page. My lord, running page would be 173, my lord. There is an additional affidavit. There we have annexed one order. When, my lord, earlier interim order was sought to be vacated, at page 190. Kindly see, my lord, the first subpara. The case of the present applicant is that is the writ petitioners were not selected by the High Power Committee for the purpose of allotment in the aforesaid market, but for which the present writ petition has been presented. According to the present applicant, writ petitioners approached this honorable court challenging the order dated 13/2/15 issued by Collector Guwahati Municipal Corporation, requesting them to submit certain additional document, particularly trade license for the purpose of allocation of stock in the newly constructed fruit and vegetable wholesale market at Pamohi. The Agricultural Marketing Board is required to take all necessary action for allotment of shop in a period of 3 months as per the direction given by the Honorable Supreme Court on 9/3/15. But since in the meanwhile an interim order was granted by this court initially on 1/4/15, which was subsequently continued, the allotment could not take place. Under such circumstance, filing of application by Assam Agricultural Marketing Board has become necessary. Mr. D. Das, learned senior counsel appearing for the affected wholesaler submits that writ petitioners were really wholesale vendors in the Masco and they were evicted in the year 2008. The fact that they were genuine wholesalers and that they were evicted by municipal corporation is borne out by letter dated 9/7/14 issued by the then commissioner in charge of Guwahati Municipal Corporation to the chief executive officer of the Agriculture Marketing Board. This letter has been annexed
No.
as an
What is the writ petition about? As of now, the guidelines were framed in the year 2020. The committee which was constituted seems to be in terms with the Supreme Court judgment. So there is no quarrel with that. So if in 2021, have they, pursuant to the framing of the guidelines, have taken a decision?
What happened, Latif? At the time of filing of the writ petition, then FI applied for allotment of rooms. What happened
Even as per the guidelines, did they apply?
They never apply.
Yes.
They never apply. In my category is in my category also. Oil also can they can note the order dated 12 to 2021. I think this I just go to. What happened was this? They never
Well,
applied so lordship. Honorable Court directed us to give the circular along with the form and one time frame has been back 12 to 2021. In the ILO.
Hey, I got you.
This is the allotment.
Yes, anyway, they have not applied.
They not applied.
Then
Within the time frame they applied lordship, and honorable court directed us to give a report before the honorable court. Accordingly, we scrutinize that what they have challenged now they are applying lordship in my affidavit, but they have not fulfilled the required criteria as per the guideline formulated by the Supreme Court. They never apply, never.
what is the fulfillment of the criteria?
Criteria is lordship. I annex in my affidavit lordship.
No, let us keep by the guideline.
Guideline is lordship.
My lord, I think my learned friend is not correct. There is an order, if your lordship will
Guideline is
kindly.
lordship. In my additional affidavit lordship.
On the second order.
No, let us keep on page 167 in Extra 2.
Yes, lordship.
What are the guidelines? What are the requirements of them?
They falls in the category 1B lordship. There
One,
are two categories lordship.
now 1B, what's the requirement?
1B requirement documents required is lordship. And
They
next
require
is-
passport size photos.
No, lordship. And before that, B, in case of the wholesalers falling in the categories 1B, any one of the following documents.
Of their tweet witness
business must
Before
before their eviction must be furnished. The trade license issued by Guwahati Municipal Corporation of municipal tax payment receipt of Guwahati Municipal Corporation, the trade license as tender or commission as issued by the Guwahati Sub-Regional Market Committee or any regulated market
Hey,
committee
do one is.
under provisions of section 13
One is.
of Assam Agriculture Produce Market and 72. Tax payment received in care form issued under Rule 21(4) of the Assam Agriculture Produce Market General Rule 75. But if they have not submit this document,
what about the right status of the what like
what happened is
because the Supreme Court does not say about that.
but they have not produced the trade license from the GMC.
No, that is okay. Not in we should consider. What about
Because we have issued earlier trade license to the data expert.
because they were earlier under the GM.
Yes, the GMC.
At that point of time, the question of them coming under you did not arise.
Not answer.
So at that point of time, TN4 was not relevant.
TN4 is not relevant.
Now asking them or not, on the ground that TN4 is not relevant, if you are rejecting their application, would it be proper?
But we are not rejecting them on the basis of TN4. We are rejecting them on the basis of 1 and 2.
Then
1 and
1 and the remain. So
That
1
is
and
also
2, they
criteria.
are to satisfy.
yes, sir. They have not satisfied. So similarly, stipulated case already disposed of by coordinate transfer, non-fulfillment of the declared criteria. Similar,
But we have to take about 3 and 4. Did the coordinate bench take note of 3 and 4?
but the coordinate trans take 1 and 2. But they have not fulfilled the criteria. In Mutata, who is the here not, TN4 not applicable to there not. Same issue though.
There is a report pertaining to the
Okay, I have annexed in my additional affidavit also. The minutes of the meeting.
Eight.
Case, my running case 161 in my additional affidavit. File on 23, 22.
and
Annex are still
I think it should be page 171.
171. Minutes of the meeting dated 26/3/2021.
How can this be the reason why? Where is the mention that they do not keep 1 and 2?
So we have discussed that the committee passed the committee after careful discussion on the exemption application. They submitted application on the basis of 12 to 2020.
Huh?
They submitted application.
And when did you frame the guideline?
They say person to
Yeah,
the
earlier guideline. Yeah, guideline issued in the year 2012. That's why guideline of Supreme Court order. We supplied.
2017.
Yes, sir.
These are guidelines of 2017.
17.
Now, where have you mentioned that you did not take into consideration that as per 1 and 2?
That is not there, but
They did not. Everybody filed an
that is not
application.
recorded.
Huh?
It's not recorded in the minutes.
Where? Basically, that is what I'm saying. Where is it mentioned?
What happened?
171.
Yes, so what happened is we ran in this exercise on the basis of the order dated 12 to 2021. Because submitted to report. So
No, it's like a report proper. Where is the mail? There are where is your notification of 28
it's at my regional application.
Eight.
Yes, okay.
And
One-
they belong
one-
to which?
167.
You belong to which one? Which association?
one B.
Okay, one.
What association?
We were actually traders in the old market, which was my lord
When you
gutted by
fall
fire.
in some association, you have.
Guwahati শাক পাচলি ব্যৱসায়ী সংঘ. But here we are before lordships in individual capacity.
No. There is a relevance why I'm.
No, my lord, I'm coming to that. What had happened, my lord, that Muhammad Murtaza, there is a name, my lord. The lordships will find his name in the committee also. My lord, he do not represent us.
That is why I'm.
And they used to serve notice upon him, not upon us.
No. There are two associations.
One Hak Pasoli.
Kindly come to 14/6/2000. That is your first document.
Yes. Fine. One
Kindly come to here.
page 87. Correct.
Now, out of there, 8 of 9.
No, my lord, 7 is represented by the gentleman called Murtaza Muhammad. We are not part of that, my lord. We are all individuals. My lord, Guwahati Municipal Corporation on an earlier occasion undertook an exercise where they have certified that we are the affected person. That document we have annexed. And my lord, who are these Pamohi things?
No.
Supreme Court
But
never
then also, you were doing business earlier.
Yeah.
You must have had a trade like.
No, trade at that point of time, they were not insisting. My lord, in that, lordship would recollect that Maskwa thing.
Understood.
And there was
2005
no question
also,
of-
there was a trade like.
No, man. There was, we didn't know, they never
Then
insisted.
you have to challenge the
No,
guidelines.
we are squatting on the road, my lord.
No, maybe, but if you were only grounds which have been given out there, you are to therefore
No,
challenge.
even that trade license part, this honorable court has dealt with that issue. Honorable Justice Bujarbur has ordered, they have dealt with that, will apply, they will give us. That order is annexed.
No. At that point of time, the trade license
No,
was not.
they never insisted, my lord. We didn't have trade license. We have made our,
Then anybody can come.
and they just collected cess. Every day they used to collect cess from.
So there will be some document to that effect you have to.
No, if your
Then
lordship
anybody
will,
can come.
my lord will kindly come to page number, yes, I'm coming to that page. Please come to page 49, my lord, of the writ petition. With reference to the subject cited above, I am to submit for it a list of genuine and deserving applicants who actually applied for relocation to Guwahati Hak Pasoli Folmul Paikari Bebokhai Khonta. The Khonta submitted a list of 100 number of traders for relocation at Pamohi. Following things mentioned below are found out on verification. 90 number of members are genuine who have possessed voter identity card as per list enclosed. Out of 90 members, 12 number of members are already running their business at Pamohi as per the list enclosed. 23 number of members without voter ID out of 20, which have already informed to the Guwahati Hak Pasoli Folmul Khonta to resubmit the voter identity. Now kindly come to the list, my lord. Next page. For example, serial number 1, Nazmul Khan, he is the petitioner number 1. 1, 2, 3, 4, 5, 6, 7.
Kindly see, kindly see.
The license.
No. Kindly come page 50.
Yes, my lord.
This
Says paid document. Yes.
and there are many who had not paid.
There are many who have not.
Trade license, there were some who were having, some were
Mostly no, not. Yeah. None of the
some were
petitioners
having,
had.
some were not.
Yes.
If you see at page 51,
Yes,
there
my
are
lord.
many who are having trade license.
Yes, yes. Some are-
Thereby, to say that there was no trade license given would not be correct.
No, my lords, no, no, I never said it could not be given. What I said was they never insisted. Actually, those who are having shops within that market, they were having trade license. We were basically squatting on the road, my lord. Possible recollect the whole road was
No, understood. If you are squatting on the road, then they have to allow you in squatting in the road in Pamohi. That's all. Nothing more
no,
than
my
that.
lord. Olga Tellis, my lord, the right was
Olga Tellis is there, but that Olga Tellis, you have to again go to Supreme Court.
no, my lord. Lordship would recollect that land belonged to
No,
him.
but Mr. Chaudhary, you have to also understand there has to be some basis.
Yes.
Something.
Then let them show from the record on what basis they have rejected our claim. End of the matter. Let them produce
But
the
that-
record.
Therefore, if I order or set aside that page 171 also,
Yes.
but what is my jurisdiction to do so?
No, my lord, my
As of now, there is no challenge to the document. Tell me, how do I do it? That is the main question.
that is there. That is, in fact, we had a discussion
Because
yesterday.
if I do it, tomorrow there will be immediately a challenge will get to the state.
Or lordships will give me 3 days time, my lord, will put to challenge them.
Because if the moment that document is challenged, or if you show that it was in pursuance, but then also you need to challenge
My
it
lord, will
something.
kindly call this matter on next Monday. In the meantime, we'll file a petition.
Anyways, I am not there. Let the other judge. But if you don't challenge that 171,
I agree.
you have to challenge that they have not taken into consideration 2 and 3. And more particularly, there were only 5 members who were present at the committee. Therefore, the committee has to be taken into account, and the committee has rejected. Only 5. Can the 5 decide in view of the judgment of the Supreme Court? Okay, 14/6/2017, where he challenged it, there consisted 9 members. So 9 members, it is okay. That order need not be challenged. It has been done properly, and there is a committee, proper committee. But can a 5 member reject it? Because it is only 5 persons who have
And
done.
that too, my lord, you not know what is the actual basis.
What is your basis? There is nothing. Some order, because you are there. There are, after all, various orders being passed by this court. Yes, please, the basic agency demands that you are to say why these people are not entitled to.
Yes.
Don't you think so?
I will then file an additional affidavit to bring on record why they are rejected. On the basis of this fine, I will bring on record.
Let them challenge.
Yes. Let this be kept pending, my lord. I'm just praying for time till next Monday. We'll bring on record that check. Or amendment का कितना था?
The record reveals that pursuant to the directions passed by the Supreme Court in its judgment dated
28/9/8/11.
29
8/11. Page
2011,
45.
passed in civil appeal number 7517/2011. And the order passed by this court on 9/2/2017 in deputy number 1852/2015. A set of guidelines was prepared on 12/6/2017 by the committee which was constituted in terms with the notification number AGA.124/2012-72 dated 28/8/2012. The guidelines, a perusal of the guideline shows that the eligibility of the candidates, the applicants, has to be tested in terms with clauses 4, 5, and 6. 4, 5, 6, and 7. Full stop. The petitioners herein fall within the ambit of the category 1B and therefore specifically required to fall to have the eligibility in terms with clause 4B of the guidelines dated 12/6/2017. A question arose during the course of the hearing that as to whether clause 4B, Roman 3 and Roman 4 would be applicable in case of the petitioner, to which Mr. N.J. Gogoi, the learned counsel appearing on behalf of the marketing board, submits that in respect to the category 4B, 1B, there was no requirement in terms with clause 4B, Roman 3 and Roman 4. He, however, submitted that the petitioners herein did not satisfy the conditions mentioned in clause 4B, Roman 1 and Roman 2. And it is under such circumstances the minute the decision was taken on 26/3/2021 in the minutes of the meeting of the committee. Thereby rejecting the application of the petition. This court, however, finds it very pertinent to observe that this rejection have not been put to challenge. And under such circumstances, without a challenge to the said reasons, challenge to the said document, the further adjudication of the instant writ petition, nothing remains to be adjudicated in the instant writ petition. Mr. K. Chaudhary, the learned senior counsel, submits that he would instruct his instructing counsel to do the needful within a couple of days. Taking into account the above, this the matter again on
26, my lord.
on
Or maybe, my lord, whenever my lordship sits, my lord.
coming on 4.
Let it be on 4. Meanwhile, we'll file it.
On 4th of March 2020.
Debut.
In the meantime, the respondent Assam State Marketing Board will be at liberty to file an additional affidavit bringing on record its document.
16.
It is your lordship. It is my lord, I'm actually sorry to mention my lord, this item accept our notice as our name was not shown in the call this number. The last occasion also, our name was not shown.
Today,
I can't know about the listing of this matter, my lord.
what remains in this matter? What is the case about? You want to file affidavit?
My lord, definitely.
Mr. N.C. Das, the learned senior counsel, submits that the respondent number 2 The respondent number 2 to 4 would like to file an affidavit with the instant repetition. He further mentioned that then his name was not shown in the cause list for which the instant repetition was not noticed on 8/1/2024, where the matter was earlier listed. Taking into account the above, is the matter on 27th of March 2024, the affidavit be filed by 15th of March 2024. The petitioner, if to advise, would be at liberty to file the file.
Public hearing.
Seventeen.
May I please, Lordship. Lordship, on the previous occasion, Lordship had instructed me to do some homework as regards sanctions in this matter. Whether in the light of Lordship's recent judgment in Smith Das.
Which one?
Sumit Das versus late Avni, Lordship had recently passed a judgment as regards sanctions in 156(3) CRPC. Lordship, however, in my case, there is a slight difference.
Yes, what do you want?
So, Lordship, in my case, what has happened is I had lodged an FIR, simply disclosing prima facie the commission of cognizable offences. Then, after a lapse of few months, when I saw that there was no development, I preferred a petition under 156(3) before the trial court, calling for the status report as to what is happening in that instant case. Then it was brought to my light that the FIR was not even registered at first place. And what had happened in this case, and this is alien to CRPC, a inquiry officer was deputed. And that inquiry officer did a perfunctory investigation. And
In your application under 156(3),
no,
by the court or by the police?
by the police. I had lost the FIR. That should have been registered, and investigation ought to have been ordinarily carried out. But what had happened was it was not registered, and one inquiry officer was deputed. And he made a perfunctory investigation, and then he submitted a report that no prima facie case is made up. That was not basically FR was not laid.
You find the FIR who?
Against certain top police officials, Lordship. That is where the question of sanction came in.
Okay. Yeah. Take another judgment, I say,
Lordship.
but again, whom? You are not making that those persons are party. Against whom you have filed an FIR? You have not made the part.
Lordship, yes. I'm not.
Then how do you survive? How can you? Didn't you have to have hear them? So they will have the right to say, but we have the right to be objective to the judgment and matter.
Lordship, right. But Lordship, my case is that I merely lodged an FIR. At the stage of FIR, whether there is
See, the question is whether the power that the 156 can be exercised to save the person concerned is required. That is the case where the court maybe judgment says no.
yes.
Earlier it was okay, but then the court said no. Then the matter was referred to Surana.
Surana.
Matter was referred to a judge, but that case is
Manju Surana.
so as of that, but if you have been for inquiry without it, then the directions can be passed. And thereupon can where only investigation. But you must have stated about the person against whom sanction is required. Then the court says the law is very clear on the fact that barely makes a reference out there to not. But
Right.
that one paragraph says that by the say that, okay, that judgment did not start without touching up to it, not for the fact of independent. That if I was fighting against some, but independent that was that was or whatever you were doing. And as such, that's not what the
Would not,
and that is the reason why I opt for the
Lordship. No, Lordship, but those judgments, the judgments that Lordship had referred in the Sumitra's judgment was Anil Kumar and Manju Surana, and those in the light of those. Now, in these judgments, Lordship, the subject matter was that a private complaint was filed under Section 200 CRPC before the trial court. And then, at the stage of cognizance, the issue of
you file the
FIR,
you file the 156B.
I did. Now, Lordship,
Valid up to the 156B.
rightly pointed out, but I merely filed the petition under 156.3 to call for status report. I did not file the petition under
It is
156.
seeking a direction to the CID to register a case and initiate investigation of the case. This is your prayer.
Lordship,
I think you are further
probably then.
last time we got it. Never to after. Now let us if it
But then, Lordship, there's more development to this.
is the main problem of this court is without
Otherwise, Lordship,
think
my
about
prayer,
it. It is the here you are making a case, doctor by taking
yes, and yeah.
without making it. And the inaction of not the responsible or any order of part or which you are to ask without they will have a right.
Lordship, probably they will have the right to approach before this honorable court when the charge sheet is laid, when the case is at the stage of taking cognizance. That is when the court applies it.
You did not come under 100.
I did not. I merely, yeah,
You came
right.
under 1. Now, 136 is therefore given. If you of the law as it stands, there cannot be a direction to directly that it or to observe the thing. It is the law. That law has not been accepted.
Why? Deeply. Deeply.
18.
Your Lordship, on the last date, they prayed for time to pass.
Something very wrong. And I
I'm not seeking adjournment, Your Lordship.
Yes, but it's okay.
Your Lordship, we are a tea state company. We take the position over the Soraido tea state on 2015. And during the recultivation, we discover a place, historical place called Maidan.
Are you want the ASI to demarcate your land? Other the survey get to people thinking very archaeological.
Lordship, it's a historical site. It's a Maidan of kindly look at annexure A, Your Lordship.
Yeah.
A. That is Page number 15.
Then what's the order?
Then after some organization complaint, the DC passed annexure C, that order, where they had directed not to encroach on the land within 300 meters. But your lordship, as per ancient monument and archaeological site and remains Act 1958, Section 2A, it clearly states that every area beginning at the limit of the protected area or the protected monument, as the case may be, and extending to a distance of 100 meters, where in the order there
Order you are
that is annexure C, your lord,
Annexure C.
page 17.
Yes, what's your stand? Comment?
Okay, yet to have one
Hello, which department is it?
archaeological survey.
No, no. Archaeological has not done. It is the deputy commissioner.
The deputy commissioner has passed the order. It is the revenue also. They have
No, no, here the deputy commissioner's
Applicants,
order,
we have to-
moreover, the prohibitory order for maintenance of peace and tranquility under 144 has been promulgated.
Yes.
Prohibiting encroachment of a proposed reserved land of Cohen, which was not under plantation. You are therefore directed to remove fencing along with new tea plantation in the above land affected by you as something 300-meter periphery of the historical document. Then, who is the PM for the Archaeological Survey of India? It is the central government. Their names have been shown. One is revenue and the other is the government is appearing.
2 and 3, and the 4th is the.
So you have no instruction.
No.
And how can there be a order of under 144
Yes.
from 2018? Is it possible?
Not all. Okay.
It has to be only valid for 2 months.
Yes.
Yeah. And if you have not extended, matter goes.
Goes up.
Should we record that submission?
But for that matter, at least, if at all it is not surviving, then
It's good. By an order dated 31/10/2018 had to notice. So till date, neither the revenue department of the government of Assam nor the district administration or either have placed before this court the instruction. This court also finds it relevant to observe that the order which has been put to challenge is an order dated 24/9/2018, passed in exercise of the powers under section 144 of the CRPC. A question therefore arises as to whether the said order still survives, taking into account nothing is brought on record that the state order has been extended or fresh orders have been passed. This court takes the matter again on 13th of March 2023-24, on which date the counsels appearing on behalf of the respondent shall obtain their instructions without pay.
Your lordship, interim may be continued.
Same order is there.
Yes,
Same order passed again.
much obliged.
19,
I'm on behalf of Bharat.
This one. Wait. You are there.
I'm appearing on behalf of Mr. H.
No, the interim order is something for the order. Soon is already there. Having heard learned counsel for the party then on due consideration, impugn notice dated 20th PI state. Is no till that. However, petitioner shall take adequate steps to ensure that no activities are taken within a radius of 100 meters of the new measure. Yeah, what is this? PTC? You file the affidavit? Huh? You file? Okay, PTC. What is your case?
Lordship, kindly peruse the page number 54, Lordship.
What is this case?
Lordship,
Non-payment of dues.
yes, Lordship, I am the registered contractor under PWD department.
Yeah.
Accordingly to
What is the stand of the authority? Do they admit
Yes, Lordship, kindly peruse their affidavit, Lordship, page number.
they say that out of 49 lakh already paid to the 48 lakh, remaining is one.
Yep.
For construction of reverse 49, already paid 30. Giving the public available. That's all.
Yes, Lordship.
So you are to get 1,49,000 and 9,99,000,
Yes,
which is
Lord.
duly admitted.
Total out of total 11 lakh 49,811. Total rupees, Lordship, 11 lakhs 49,811.
No. They say only you are entitled to 1,49,988 and 9,99,000.
Yes, Lord.
That's all.
Yes, Lordship.
The instant petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authority in not making payment of the petitioner an amount of rupees 99,99,053. Under such circumstances, the petitioner has sought for the said amount along with interest at a rate of 18% per annum. The record reveals that pursuant to the notice, the respondent number 5 has filed an affidavit to the opposition, wherein at paragraph number 4, it has been duly mentioned that in respect to the construction of Paneri College approach route in Udalguri (RNB) division, out of the total amount of 49,99,938, the petitioner have already been paid 48,49,950, and the remaining balance is rupees 1,49,988. In respect to it was also mentioned that in respect to the construction of the road Kalsipa to Paneri College in Udalguri RR division, out of the total of rupees 49,99,115, the petitioner have already been paid 39,99,292, and the remaining balance is rupees 9,99,820. Taking into account the above stand, it is the opinion of the court that above stand taken by the respondent number 5 in its affidavit, it is the opinion of the court that if the petitioner is entitled to any balance amount, the same is required to be paid. Therefore, this court directs the chief engineer, PW, it will be Cooperative is whom? Additional chief engineer. Who can verify? The payment will be made by whom? By him, but under whom? Additional chief engineer.
Secretary BTC.
Huh?
Secretary BTC, Lordship.
They will pay.
Yes, Lordship.
Therefore, direct the secretary BTC
And
Cooperative, either by himself or through his delegate, verify as to whether the petitioner is entitled to any further amount in respect to the contract in question. It is further observed that if on such verification, if it is found that the petitioner is entitled to the amount, to any amount, the same be paid to the petitioner. The said exercise be completed within a period of 4 months from the date a certified copy of the instant order is served upon the secretary.
Yes, Lordship.
Yeah.
They were called in the meeting and everything, but after hearing the opportunity was given, and thereafter shifting to. In fact, when in the civil court, it has been settled.
Right.
Only license or trade license. Okay. Yes.
Trade like what for the purpose?
But the order came for 16, and these are the when the business was, they are doing the business, they will be affected. So they were called up. And the meeting was taken place, proposed notice of reply was given. Thereafter, that particular temple has to be shifted to the place where they were running. But they have to be shifted to other place. Only within the same land. And ultimately, what I know, in the civil court, it has been settled. A long litigation from 1963. So the land was somewhat held, was given to CPP. Then the market started. Ultimately,
But it's a municipal market.
that particular land was donated to the municipal market.
So they were allotted.
They were given the license, and they took
A license as a allotee or as a license as a trade like. Not an allotee.
they were given only to trade like. But the fact that the shifting will be taken place, that particular place, they were running the market, so they will be affected. So they have to, their hearing was done, they were given proposed and everything was. In fact, the civil court has settled the issue. Civil court has settled the issue.
Let us see. What is the judgment of the civil? Rafia's car. Biswajit Bhumik. Sir, Biswajit Bhumik.
No, we are not a party to the, because the civil suit in between KMC and the owner of that plot of land. An agreement was executed in between them. And some portion is required to be handed over by the GMC
Okay.
to them.
Now,
and the
what
rest-
is this? What is the judgment passed in the civil court? You were in the area where the mandir was to be set up?
Yes.
And on the basis thereof, this order was passed on 23/10/2017,
It is in between GMC and the,
whatever may be.
yes, yes,
That is an order being passed.
Yes.
In the execution, and thereby asking you to vacate, to shift.
the, because they have not handed over the 3 kata 8 lessons.
I'm not on that. This court directly directed that the area may be identified for the purpose of the Kaliman.
Correct.
Now, accordingly, the GMC identified it and
My
issued you a notice on 23/10/2017.
Absolutely correct,
This you have put to challenge.
my lord.
Now, thereafter, what
My-
happened?
Then Lord, this honorable court, my lord, passed an order that lordship will find in page 74, 75, 76, the last order.
So, there was a direction that these 7 shopkeepers,
My lord,
there will be an opportunity of hearing.
my lord,
And thereupon, till it is not being heard,
my lord,
you are not to be evicted.
my lord, absolutely.
Then what happened?
My lord, then we have communicated, although the standing counsel was there, but we have communicated that next page 77, honorable court order. But in spite of that, my lord, 78 page number, they have issued this.
Again, why are you challenging the same order of 23/10?
Now, lordship will kindly see the page 78. After passing
Of the
of the writ petition,
second,
that 2650, my lord.
Page 78.
my lord.
Yes.
Now, lordship. Page 79, last. After passing the order, my lord, of this honorable court, they have stated we have not taken any steps pursuant to their.
There's no response from the aforesaid
Yes, my lord.
person. Therefore, so and so is given another 7 days.
My lord.
Therefore,
Now, we have.
then you
commi-
submitted your reply.
Yes, we have submitted our reply,
Then thereafter they demolished it.
my lord, without any opportunity.
So what is wrong? What additional opportunity you want? You want to go and appear before the JMC
No.
commission?
We are not opposing the my lord decree or nothing here. We just only to accommodate anywhere in that area, my lord. That's all.
That is not your case.
Yes, we are seeking that prayer also. Alternative
Where?
prayer is there, my lord.
To provide an opportunity of hearing. Writ of mandamus to provide alternate place for business in Polton Bazaar area during the process of building of the shop so that petitioner can carry out the business without any further loss. But this will depend upon as to whether you were granted an allotment earlier or not. It's not there. So you were evicted after
On 18/12, my lord.
on 18/12
My lord.
after your reply has been submitted.
My lord.
So done property. What else do you require?
We have only communicated that as per the High Court order, we have to give an opportunity
Of
hearing.
hearing means
So there is other order from the court that they should be called in that alternative arrangement, if possible, that should be taken care of.
Hmm?
Alternative arrangement, if that is
first of all, for that you need to satisfy the court that you have some right earlier.
my lord.
But how can this court create a right upon you
My lord.
on the basis if you didn't have a right? There no affidavit has been filed
Take up my affidavit in
in the contempt.
no, in the meantime, my lord,
The
Commissioner
Mona Lisa
has been
Guptami is
transferred.
no longer there.
no longer there. He
But
is
the
that-
question is who violated at that point of time? It is not a question of enforcing, it is a question of a violation. So the violation happened by then. And having not filed an affidavit, couldn't we hold the to in contempt?
I have not lot. Before that,
After
one, we
issuance
turn
of
out to my
notice.
affidavit, page number 12, madam. How
But-
hearing has been conducted.
Huh?
Page number 12 of my affidavit.
No, there is no affidavit filed. In spite of a notice being issued.
In read petition, madam.
Forget about it. It is a serious case. Notice has been issued to you.
In the he
Where
has
is she
retired
now?
long more than 5 years back.
Where is she now? Mona Lisa.
He has retired. He has
That
retired.
do you want to proceed against her?
Or lordship will grant look one of days.
For what? After so much of time being spent, 15 minutes,
My lord, and
you want to proceed against her?
my lord, is contempt there.
And you have filed your wakalat number on 24th.
In the meantime,
have
he is
not-
dead.
Thereafter supplied your affidavit.
But in the meantime,
So
he
we
is
will
dead.
conclude that you have all the statements made in the contempt petition are true. And thereby
My lord,
to
Lord will give me an
advocate
opportunity to
contempt
find
against her.
love where he has retired my life. Then
So what? Retired means if a person retires, that's a violation. If somebody is within that be a violation.
then I have to face her out my words.
Can you say you are not appearing as a standing counsel? Who is appearing out there?
Not just standing up, the private advocate I'm a because that's why
Private, who is appearing for this?
I have filed a color number.
Who has filed the wakalat number?
I have filed.
So if you have not filed it, so we'll take it as if you have nothing to say.
Will give me an opportunity, my lord.
For what opportunity?
Because in the
After
meantime,
2018,
my lord, more than 5 years.
high time a person goes behind jail. will initiate contempt proceedings against her for not filing.
Also give an opportunity, let me contract how it
Nothing
is available in.
Your GMC has taken, have not at all interested in the, yeah. Earlier there was another matter where the GMC has not appeared. And for that reason, we have to adjourn it. I have done directed personal appearance of the commission.
That's not another thing.
So under such circumstances, when the
Not
GMC
given
is not
one
bothered
opportunity, my lord, I will.
to help in the process of the court, why should we? Better you go behind the bars and then one fine morning, otherwise file a appeal before the
But will be one
Will hold-
opportunity,
hold it in
let me find out first thing.
What?
But one opportunity,
for what?
whether if he wants to file an affidavit, my lord.
He
But
doesn't
in the
want to
mean-
file
in the
an
mean-
appeal.
in the
After
meantime-
6 years, are you saying that are you not supposed to purge your contempt first?
my lord, in the meantime,
Why should I hear you? And that too on affidavit, are you not
In the
supposed to
meantime-
purge your contempt?
in the meantime, yesterday we stated that new incumbent.
Why should he? Is the new incumbent responsible for the violation? Or are you in a continuing violation? No. You, in spite of an order being passed by this court not to evict them without giving them a hearing, you have evicted them.
Lord, then my lord, Lord will turn out to my affidavit, my lord,
Why should I look into it?
because hearing has been done, my lord.
There's no hearing. He has only submitted a reply.
Well,
No hearing was given.
My lord, Lord, hearing is done, my lord.
Where?
I have filed a hearing, the order, full order, my lord.
Where?
In petition number 2650, my affidavit. Page number 12. They all were present, man. Annex of 5. All were present, all names are recorded. Right, put into your hearing.
This was given when?
It was signed on 19/5/2018.
Huh?
19/5/2018.
He submitted his reply when?
8/12, 8/12/17.
Huh?
8/12/17.
8/12/17. A year back, day after they have taken the eviction.
Now you were evicted when?
18/12/17, my lord.
18/12/17.
My
And
lord.
this hearing has taken place on 17/5/2018. After throwing them out. What type of hearing is this? After demolishing somebody's house, now you do the hearing. It is similar to the submission which we have made that the new incumbent should be made. You are not concerned with the new incumbent. Who has committed the violation then?
Action was taken on 18/12/2015.
Huh?
Yes.
You evicted them on 18/12/2017.
My lord.
Then that's a consolation hearing or what?
Yes.
Huh? Or you just have to hear, give them a hearing. Wouldn't this categorically show
Not to be turned to.
there is no room space for reallocation of the evicted in the same place? Further, the land
Yes,
in terms with the agreement is not
wanted
yet
a
handed
second
over
floor.
and transferred to GMC by Nazim, and also huge fund is required for any upcoming. Therefore, accommodating in the same market at this stage will not be possible. Moreover, 4 acres of land has already been given to Kali Mandir as per the agreement, and as such, the construction of the edge of the first floor as suggested by the architect. So this hearing is for the purpose of accommodation.
Yes.
That is an apparent violation. So we initiate contempt against. We initiate two contempt. Once again, him, like the people of it against you. Go to the two repetitions as well as the contempt application are taken up for final disposal by this common judgment and order. The petitioners in WPC number 6675 of 2017. The petitioner in WPC number 6675 of 2017 claims that Deputy Commissioner Kamrup had acquired land at Pokon Bazar belonging to the Shah family for opening a market. The petitioner's mother, late Renu Konade, was running a shop since 1960 in the said market. Thereupon, the state authorities developed the said land and was called the municipal market. And after the coming into effect of the Guwahati Municipal Corporation Act 1971, the market was constituted as the Guwahati Municipal Corporation Market. It has been specifically stated that the petitioner mother was allotted room number 17 at that point of time. However, there is no document enclosed to the writ petition. It is also relevant to mention that the said land wherein the petitioner claimed that a room was allotted to the mother of the petition is part of a land measuring 3 kathas, 8 lechas, covered by dark number 3217 part under KP Patta number 397 of Sohor Guwahati Paltan Bazar, part Moza Ulubari, which was renumbered as dark number 2564 of draft Patta number 95. A litigation was fought amongst the owner of the said plot of land measuring 3 bighas, 8 lecha, 3 kathas, 8 lecha, along with the government of Assam and the municipal corporation, wherein various persons who were occupying the said land were also parties to the said suit. The said suit was registered and numbered as title suit number 1/1991. By the judgment and decree dated 29/10/2003, The learned court of the civil judge number 2, Amrut Metro at Guwahati, decreed the suit in favor of the owners, declaring that the plaintiffs were entitled to release of 3/8 letters of land as detailed in Schedule B to the plaintiff from acquisition in terms with the agreement dated 19/1/85 and entitled to a decree for mandatory injunction, thereby directing the defendant to release the said land from acquisition and to deliver possession of the said land to the plaintiff, and also a permanent injunction restraining the defendants from constructing any building or structure disturbing the plaintiff's possession over the Schedule B land. The said decree had attained finality, as there is nothing on record which shows that the said decree in any manner was overturned. The record further reveals that execution proceedings were initiated on the basis of the said decree, passed in title suit number 1/1991. In a collateral proceedings to the said execution proceeding, an order was passed by this court in CRP number 322/2016, dated 8/5/2017, wherein this court specifically directed the GMC to identify the site for shifting of the existing Kali Mandir within the land covered by dark number 3217 old 564 new as per the identification and within the said identified area made by the district administration. This court further directed that the process of identification of the land to be completed by the GMC within a period of 1 month from the date of the said order, whereafter the Mandir committee was bound to shift the existing Mandir to the site handed over by the GMC within a period of 1 month from the date of such delivery by the GMC. For the process of handing over of the possession of the land to the Mandir committee, the district administration was also directed to render all necessary and possible assistance to the GMC. Further to that, the executing court was also directed to carry out the process of execution of title execution of case number 6/2008 pending therein as per law. It is relevant to take note of that these 4 leases of land this land, which was to be handed over to the Mandir committee, for the purpose of construction of the Kali Mandir, is the land wherein the petitioner in application number 6675/2017 was carrying on business activities. It is under such circumstances a notice was issued on 23/10/2017, whereby the petitioner, along with others, along with 6 others, were directed to shift from the site identified for shifting of the Kali Mandir within 10 days of the receipt of the order for smooth execution of the order dated 8/5/2017 passed by this court. This order has been put to challenge in application number 6675 of the 2017. The record reveals that this court, by an order dated 8/11/2017, issued notice and further observed that the pendency of the case would not be a bar for the Commissioner GMC to reconfirm the area for shifting of the Kali temple in terms with the direction passed by this court by affording opportunity to all the 7 shopkeepers named in the notice dated 23/10/2017. It was also observed that without such opportunity and affording hearing, the impugned order dated 23/10/2017 shall not be enforced until the returnable date. Thereupon, the writ petition was listed on 8/12/2017. However, the said interim order was not extended. Be it as it may, an affidavit in opposition has been filed by the respondent number 2 and 3 pursuant to an order passed by this court on 18/12/2017. Wherein it has been mentioned that the pursuant to the order dated 8/11/2017 passed by this court, the Commissioner GMC issued an order dated 30/11/2017 to the writ petitioner and 6 others, directed them to show cause within 7 days as why they should not be evicted. In pursuance to the said notice, a reply was submitted on 8/12/2017. Thereupon, the Commissioner GMC, by an order dated 15/12/2017, directed to reconfirm the area of shifting of the Kali Mandir to the petitioners and 6 others upon failure to give a suitable reply against the order dated 30/11/2017. And it is under such circumstances on 18/12/2017, eviction operation was undertaken by dismantling 7 numbers of shops of the GMC market, Polton Bazaar, identifying 4 lectures of land where Kali Mandir was proposed to be located. This court at this stage finds it pertinent to take note of the reply submitted by the petitioner to the notice dated 30/11/2017. Which would reflect that the said reply had nothing to do on the merits of the claim of the petitioner, but was on the basis of pendency of the petition number 6675 of 2017 and the order dated 8/11/2017. This court further finds it relevant to take note of that an affidavit in opposition was filed by respondent number 2 and 3 on 2nd of November 2018. And in the said affidavit in opposition, it was categorically mentioned that there was no documents placed on record by the petitioner to show that the stall number 17 was allotted in the name of his mother. And the petitioner was put to the strictest proof thereof. It was also mentioned that the money receipt encloses Annexure 1 to the petition is in the name of one Sri Hari Sandan Bhomik and not in the name of the petitioner. The remaining portion of the affidavit in opposition are in terms with the narrated facts for which, for the sake of brevity, this court is not repeating. The record further repeats that pursuant to the eviction of the petitioner on 18/12/2017, the second writ petition was filed by 4 writ petitioners. Wherein, again, the entire process of issuance of so-called notice, the entire process of issuance of the order dated 23/10/2017, the show cause notice dated 30/11/2017, and the eviction process on 18/12/2017 was put to challenge. It was also mentioned that the petitioners were not given a reasonable opportunity of being heard. Further to that, it has also been mentioned that the respondent number 3 be directed to provide alternative place of business in Polton Bazar market area during the process of rebuilding of all the shops so that the petitioner can carry out the business without any further loss. Around the same time, a contempt application was filed by the petitioner in WPC number 6675/2017 against the then Commissioner, Guwahati Municipal Corporation, alleging violation of the order dated 8/11/2017 in as much as no opportunity of hearing was provided to the petitioner prior to eviction. The record reveals that this court had issued notice as far back as on (21/3/2018) and till date, the said respondent, in spite of filing their affidavit, their wakalatnama being in spite of the council submitting their wakalatnama on 24/2018, have not filed any reply. The record further reveals that an affidavit in opposition has been filed by the respondent number 2 and 3 in WPC number 2650/2018, wherein the facts already mentioned here in above have been mentioned. However, it is relevant to take note of that a hearing had taken place on 17/5/2018 at the Guwahati Municipal Corporation office called Panbazar at 3 p.m., wherein all the 7 persons, wherein 9 persons, 8 persons were present along with the officer, which included the petitioners in both the writ petition. During the course of the hearing, it was decided that there was no room or space for relocation of the evicted persons in the same place. And it would further require huge funds for any upcoming project. It was also found that as the construction of the mandir on the first floor, as suggested by the members present, does not arise. In the backdrop of the above pleading, this court have also heard the learned counsels appearing on behalf of the petitioner, as well as the respondent, including the counsel representing the respondent, Contemla. The materials on record and the submissions have been duly noted. In the materials on record, it is clear that the GMC had no right over the land measuring 3 kata 8 letter, which was the subject matter of Schedule B to title suit number 1/1991. Inasmuch as the said judgment and order, judgment and decree have not been put to challenge. This court also finds it relevant to observe that by an order dated 8/5/2017 passed in CRP number 322/2016, there was a specific direction passed by this court directing identification of a specific plot of land for the purpose of construction of the Kali Mandir, and thereupon to hand it over to the Mandir committee for construction. From the materials on record, it also transpired that these 4 letters of land, which was duly identified, was the land wherein the petitioner, along with the petitioners in both the writ petitions, were carrying on business. This court also cannot be unmindful of the fact that there is no materials placed before this court that the petitioner in WPC number 6675/2018 or the other petitioners in WPC number 62650/2018 were allotted any area over by the municipal corporation. This court also finds it relevant to take note of that in the affidavit in opposition filed by the respondent number 2 and 3 in WPC number 6675/2017, there is a denial to the effect that there was any allotment made in favor of the mother of the petitioner. And in spite of that, the petitioner did not, for the last 6 years, file any document showing that there was any allotment. Be it as it may, In view of the judgment and decree passed in title suit number 1/1991, even if any allotment was made in favor of the petitioner or their predecessor in interest by the municipal authority, but in view of the direction, in view of the judgment and decree dated so and so, the municipal authority had no right over the land in question, and consequently, the right, if any, created by the municipal authority over the said land has also ceased to exist. In the backdrop of the above, it would also be seen that that in compliance to the orders passed by this court on 8/5/2017 in CRP number 322/2016, as well as the orders being passed in title execution case number 6/2018, arising out of the judgment and decree dated 12 in title suit number 1/1991, judgment and decree dated 29/3/2018. The order dated 23/10/2017 was passed, whereby there was a direction to the petitioner in WPC number 6675 of 2017, along with 6 others, to vacate. This court, by an order dated 8/11/2017, protected the petitioner to the extent that an opportunity of hearing would be given. It is the opinion of this court. Thereupon, it is seen that on 30/11/2017, the petitioner in both the writ petitions were given an opportunity to submit a reply within a period of 7 days by the show cause notice dated 30/11/2017. Thereupon, the record reveals that on 8/12/2017, the petitioner submitted the reply. The reply, which is a part of the affidavit in opposition filed by the respondent number 2 and 3, categorically shows that nothing has been stated on merit or any right of the petitioner over the land in question. The entire reply hinged upon the pendency of WPC number 6675/2017, as well as the order dated 8/11/2017. Thereupon, the petitioners were evicted on 18/12/2017 after passing an order dated 15/12/2017. In the opinion of this court, there is no violation, therefore, to the order dated 8/11/2017 passed by this court. The consequential effect of this declaration by this court that there is no violation to the order dated 8/11/2017 is that the contempt proceeding so initiated against the respondent contender, being contempt case C 108/2018, stands dropped. This court also is of the opinion that the eviction carried out on 18/12/2017 has been in accordance with the provisions of law, and more particularly in terms with the directions passed by this court on 8/5/2017, and also the title execution proceedings being 6/2008. Therefore, the eviction of the petitioner does not call for any interference, more so when the same was duly preceded by an opportunity to the petitioner. In the backdrop of this court further takes note of the relief sought forth in the petition to the extent that the petitioner be accommodated in some other area. In the instant petition, the petitioner have not placed any document to show that the petitioners were earlier granted any allotted by the GMC authority. And under such circumstances, it is difficult on the part of this petition, on the part of this court, to pass a direction. And under such circumstances, it would not be in the interest of justice to pass a direction upon the respondent authorities, more particularly the GMC, to grant an allotment at some other place to the petitioner. However, this non-granting of the state relief as sought for by the petitioner would not preclude the petitioner to approach the GMC authority for allotment in some other area, and by showing documents to the effect that the petitioners were earlier, petitioner or their predecessor in interest were allotted earlier, granted allotment earlier, and thereupon have not been able to, and thereupon requires an allotment for running for the petitioner's livelihood. With above observations and direct the above instant proceedings, then but Mr. Bora, yeah.
Item 20.
Yes, madam.
Status report, Lordship, I produced for your Lordship, madam, subject, but Lordship directed me to give a copy to the petitioner, madam.
You've given
Yes.
Lordship, on that day itself, madam,
it is on what?
regarding, madam, the
Extraction.
missing girl. One girl was missing, madam. Lordship directed me to know about that, madam, to get the information regarding the doctor, madam.
Yes, I gave you this
Lordship.
copy. On
Yes.
the earlier occasion, there was one lady appearing.
Madam.
I
Yes,
gave
ma'am.
you that copy only for making a submission before the court or placing something on materials on record that the investigation has not been done properly. If you don't do it, how can this court further proceed? Otherwise, they have already done it.
Lordship, paragraph 10,
My
madam.
lord, I have gone through it, my lord, but I have not submitted any written. My lord, so far, my lord, the point which was given, my lord. So, my lord, this is not conclusive, my lord.
So you have to do
Yes.
something. That is why I gave you the copy.
Sir.
You are merely saying not conclusive, could not do. They have not been able to
Sir.
face up against the learned counsel appearing on behalf of the petitioner.
1 week time.
Further accommodation of 1 week's time to apply for as regards as whether there has been any deficiency in the investigation. It is because the learned counsel, if the learned additional senior government advocate submitted that on an earlier occasion, pursuant to the order passed by this court on 19/1/2024, a copy of the instruction dated 18/1/2024 was duly served upon the learned counsel for the petitioner. The same having now been placed before the court, kept the report are by this is the matter again on 28th of February.
How like?
May we talk about it
Mm.
regarding the post of president of Nalbari Jilla Parishad for women, what not, yes, that
Period over.
period is over. Structures,
Period.
One thing, my lord, they will
We'll
issue
keep the
not-
question open.
Yes, yes. Because the notification may is
Mr.
to
R. Uttami, the learned counsel appearing on behalf of the petitioner submit that that during the pendency of the instant petition, the period of the docket
Jila Parishad, Nalbari Jila Parishad.
in question is over. The term of the Jila Parishad in question is over. And as such, the question which have been raised in the instant proceeding as regards the reservation of women in terms with
Section 71A of the Assam Panchayat Act.
section 71A, 78, 78 of the Assam Panchayat Act 1994 does not survive. He, however, submits that the question involved in the instant proceeding, the instant petition be closed as infractured. However, keeping the question involved in the instant proceedings open. And if the petitioner is aggrieved on a and keeping the question open. Taking into account the above submission, the instant petition stands closed as infracted. However, the question which was raised as regards the application of section 70A of the Act of 1994, insofar as regards the reservation of women, is kept open.
Obliged.
That's the central rule, Your Lordship, not the Assam rule. Your Lordship, Rule 13 says, Your Lordship, recovery of excess amount. In the case of any default or refusal to pay the excess amount as referred to in subsection 3 of section 33 of the, Your Lordship, the central rule, Your Lordship, the right to fair compensation and transparency land acquisition regulatory settlement rules 2015, Your Lordship. In the case of any default or refusal to pay the excess amount as referred to in subsection 3, section 33, the same shall be recovered as arrears of land revenue under the provision of Revenue Recovery Act 1890. And such recovery proceedings shall be initiated within a period of 3 years from the date on which excess amount rules. Lords.
Now you have not been able to activate
Lord. No, I have not, Your Lord. I have, Your Lord,
you had 39 lakhs,
39 lakhs,
which you have not picked out within the
39.
which 16 your
22 is, Your Lordship, disputed. Now, even otherwise also, Your Lordship, under section 33,
I need to give in an opportunity, your lordship, proviso, your lord. Provided that,
I understand that.
Lord.
Yes, it is. But that is okay. But how do you check when
your lordship, that your lordship may till a final decision is
but not if your where is that
Lord.
that is the
Lord.
Right.
Lord.
Start with the day for the day of
Lord.
the
2 weeks we can wait, your lord, since we have waited. Lord. Lord.
first eat then to also created
Lord.
that's the best
Lord. Lord.
The very and whether it's on correction
Lord.
and because one thing very clear, it does not have the power to review. But the deputy does not take the land for its own. Why the land was taken?
National highway.
National highway when state or anything.
NHAI.
NHA are part
Here, your lordship, NHAI is not part.
of the why this not under the not under the highway.
No, your lordship, they say, your lordship, there are two. Its statement is that this has been done under National Highway Act.
So if that is so, then NHA can take the part
Lord. They can go for
which is not permission here.
Lord. Arbitration is permissible under National Highway.
Here the requiring of it cannot go as per the but NHA it fine.
Go, Lord. And your lordship, if your lordship comes to page 45, annexer, they have annexed with the affidavit. It says that they have applied the calculation, they have applied the as per the schedule, schedule of the right to fair compensation and transparency. Lord, they can.
So they had Highway Act was not the but that was the
Lord.
thereafter
Lord.
But so the only way they ask them what the host is the correct but whether the it is the correct so here
Lord.
whether
Now your lordship will
order correct it clerical whatever I did I did
Lord.
Without having a paper
Lord.
without any
And your lordship, how I prejudiced ultimately, your lordship, I have satisfied with the award. Now I did not go for your lordship higher compensation, your lordship. Now the moment they say that you have been paid a higher compensation, your lordship, in the meanwhile, your lordship, time for going for that, Lord, that is also there.
and let's up right after the passing by the court by the court can correct, can apply a different multiplication factor as dictated in section 26(2) of the right to fair compensation and transparency in land acquisition, rehabilitation, and legal act of the 30. It is admitted clear from the peripheral that the activity was done under the of the National Highway Act 6, and the compensation was paid in terms of the Act of 2013. The Kotaku writing National Highway Act
Lord. I will file in the meanwhile, Your Lord.
accordingly the court was of opinion that the petition would be reported of the that the National Highway Authority of India, having its office at, you have the
Lordship, I will collect.
you just provide,
Lord.
having its office at so and so and represented by so and so, is required to be made a party to the incident. According the National Highway Authority of India, represented by is the delegate, is made the respondent number 6 is imputed as the respondent number 6 to the incident proceed. The petitioner is directed to file a fresh memo party before the registry of this court on the basis of the incident order by 16th of the petitioner is also given the liberty to serve a copy of the receipt as well as the pleading. Other pleadings have been exchanged between the parties to Mr. C. Borua, the learned standing counsel for the NHAI. It's the matter on 5
Deeply obliged.
because every indictment,
Lord.
we may not be able to apply because only the determination is there from 26 to 30. So we cannot apply 33, or in other words, schedule 1 will be applicable. So if we can't apply 33, what is the cost?
Lord.
23,
Yes, madam.
The file is already up, my lord, for the concern officer, my lord, they need to move it back
Aye.
to
Is holiday
cabinet, authorize cabinet, my lord, they
submitted the responding authorities seek the photo additional 4 weeks for the purpose of placing the final decision before the
morning, they technically start
how much
2 weeks, my
Mohanto, Mr. T.R. Mohanto, the learned counsel, is appearing on behalf of the Revenue and Disaster Management Department, seek for another additional 2 weeks. It's the matter again of 11th March, on which day the instruction as regards the decision which is required to be taken, be placed before
obliged.
tw- 28,
The lead case is 8/30/2020 and matter pertain to non-payment of outstanding dues. Oh, my lord, the basic factual matrix of this case is that, my lord, in 2016, my lord, a work order was issued in my favor. Now, in terms of that work order, I have to execute the scheme for water supply in different phase manner. Now, against the compliance of each phase manner, I have to be paid. The first part of that work is to start design and drawing, and second part is soil testing, and third part is my lord, construction, etc. Now, my lord, in this case, first part and second part we have complied with. That designing, drawing, and second soil testing. My lord, thereafter we have raised the bill. That bill was not paid. We, my lord, communicated with the department in respect of, my lord, claim of amount that has not been, my lord, responded. Finally, we approached before this honorable court at first round of litigation. Now, while, my lord, we have first round of litigation, there are 6 numbers of districts, my lord. We have clubbed together one writ petition. And with the liberty of this court, my lord, we have filed a fresh individually, my lord, the case. Now, in between, my lord, what happened, my lord, they in a very revengeful manner cancel the work order, my lord. My lord, that cancellation of work order took place without giving any opportunity of propose, etc., my lord. And that was contemplated just after, my lord, once we have withdrawn filed second round of this round of litigation, my lord, this is the action they have contemplated. Is a case, my lord, while they have filed their affidavit in opposition, their basic stand, my lord, they are not denying about the compliance, completion of work. What they are saying that we failed to maintain the schedule, number 1. And number 2, their claim is that so far this submission of bill, etc. are concerned, which we have not submitted in proper terms. Technically, it is, my lord, default they are now raising, my lord. And out of which, my lord, the 6 work we have done. Out of 6 work, my lord, drawing, designing, 2 works we have completed 80%. Now they are admitting that it is not 80%, it is 50%. Suppose we have claimed 20 lakhs, they are now agreeable to pay 22 lakhs out of suppose 6. Now the situation is that, my lord,
You are agreeable to take.
no, my lord, my claim is 29 lakhs.
Are you agreeable for 20?
My lord, the situation is that, my lord, I am totally now empty pockets, my lord, because bank is running after me. Definitely, my lord, I will accept to, my lord, that amount. That is not the issue. My lord, issue is that, my lord, in affidavit, my lord, reply. Lordship wants to contain more than 7 lakhs, my lord, it will very hard to accept. But anyway, my lord, affidavit reply, my lord, we have submitted and placed all the documents that in respect of the documents which are putting in questions, my lord, that has been rightly, my lord, submitted before the concern, or there is no dispute to that effect, my lord. But that is the issue now, my lord, that has to be, my lord, dealt with by this, my lord, honorable court for adjudication.
So you are challenging your termination.
But termination was the part of the challenge, my lord, because since that suppose notice, my lord, no, in fact, it's not because, my lord, so that termination was took place.
Let us exclude the
My lord, amount they have to pay, my lord. They have to pay the amount, my lord. That work which I have already done. My lord. Yes. My lord, nothing, sir, because, my lord, out of 6 phases of work, we have completed 2 phases of work, my lord. Since, my lord,
you accept the
because, my lord, termination.
no. Accept the then you,
Exactly, my lord, because if I accept,
so you cannot accept the
absolutely, my lord.
Wait.
In this case, my lord, the reason is behind, my lord, that so far this termination is concerned.
you have a
My lord, yes, my lord. The arbitration, lordship had dealt with a 2 hours hearing. That is also order reflected by lordship dealt with, and ultimately a Unitex case, my lord, that has been considered. And once things satisfied, lordship by virtue of order dated, directed 2/2022, lordship had dealt with this issue. Arbitration clause, they have raised this issue earlier round of kind of that situation. And finally, lordship come to that conclusion since that it is not only a case of dispute in respect of amount, etc., but because of that termination letter that has been issued, which also violates the principle of natural justice and that attracts the Unitex case 2021.
and because the other
But dues are concerned, they are not dues are concerned, their stand is different.
they are saying,
No, my lord, only in respect of 2.
therefore I say you are agreeing that
My lord, out of
it is
6,
despicable.
Only that amount, that is
my lord,
You
that
must
is,
take that
no, lordship, that is not a case. My lord, there are 6 cases. Out of 6 cases, 6 cases we have completed second phase.
whether you have completed MIQ, it has to be on paper that you have completed that document.
My lord, yes, exactly, my lord. That so far their question is concerned that we have not completed the work or whatever, my lord. Supporting to that, my lord, their own signature document of the chief engineer, etc. in affidavit reply we have submitted. So therefore, there is no dispute that work we have not done. What they are raising in the affidavit in opposition, they are saying that we have not placed the bill in, my lord, a proper format. Number one, and so far 6 cases are concerned, or 6 works are concerned. We have out of this six work, 2 work we have done 80%. They want to say it is not a 80%, a case of 50%.
So you accept 50%, then I have to direct.
Yes, my lord. So far, my
You
lord,
accept
my lord, this is not a big amount, but question that the entire case covered more than 1 crore, my lord. That is the whole issue, man. That suppose that I have to accept this is not a bigger issue, my lord. That can be adjusted.
that the arbitration is there.
My arbitration is there, my lord. This issue, lordship has already dealt with in serious, my lord, in a
Not
very,
in a, not as because the
my lord.
payment amount I have because the termination. It is right.
Arbitration, no, see, agent hold dealt with, my lord, because they raised the.
But look at I can only hold the termination back,
My lord, no doubt.
not give you that work.
My
That
lord,
I,
actually, lordship can see that.
so the question that there are, it is right.
Right.
Is whether it terminates the direction of
That will go.
that,
That will go.
that the risk perspective.
Then lordship can see that if there is a, my lord, serious dispute, yes, lordship definitely read court has no jurisdiction. I'm the,
Serious dispute. I'm coming up with another judgment wait. Where I'm saying that a 50% of the question of money cannot be.
that will dangerous.
It has to be based on a legal declaration and the money of there. Just for example, the termination was self-pity on file the after
My lord,
whatever it-
yes,
and in consequence thereof, the consequences thereof because they were entitled, then can
my lord, but situation notice quietly, my lord, place it that because so far the termination is a matter of suppose 226, but rest part is a matter of arbitration. But lordship, in another view also, my lord, can see also, lordship, that if suppose this test will be done at the initial stage, threshold stage, no problem. My lord, the entire proceedings are over. And my lord, the matter has been otherwise taken place.
understood. But what is
My lord, exactly, my
no,
lord.
no, that this court that you verify, you will come to the same thing. The case verified, the entitled to this matter ends.
My
Can
question.
this court now look into it? You have completed 50%. Where is this place? Where is this place where the construction was done?
My construction is not an issue. But
Where is the place where you the construction site?
my lord, that pertain to my lord, this is Nagaon district, my lord.
Okay. We go to Nagaon and
Yes,
take the
no
site.
problem. Because my lord, they are admitting. My lord, it is not a case suppose.
What do you want?
My lord,
That is
another
some other
date, my
day.
lord. Let me get
Let
my
it have
instruction.
it after 2028.
My lord, the person will
We
take a.
issue rule on a very important question.
No, my lord,
Then
lordship, the person is really in a very big financial crisis, my lord, because of my lord, result of this amount by the department, my
there
lord.
is no financial crisis. Everybody knows when a person is
But they have invested a lot, my lord, and my lord, since 2016, my lord is fighting for his rights, my lord. Lordship, after 2 weeks, my lord.
no. At the request of the if that matters then returned to be listed again on 28 to 2024. It's up before any other.
My lord.
30.
There's what is this?
So there is the non-payment of higher charge bill, man. Way back, my lord, 2021, my lord.
Instructed.
The outstanding was particular just 4 vehicles, lordship.
Huh?
Particular,
30 lakhs, 24,425.
because they have already received 21,76,000.
They have received.
Yes.
And anything more?
Yes. According to 8,47,987 are, but
these vehicles are not included in the description. Because in this description, there is only 2 vehicles.
Mr. N. Goswami, the learned counsel appearing on behalf of the respondent, submits that he has received the instruction and would like to file an affidavit. Matter of how much time? It's the matter on 20. That will be filed by 11 of
You are.
May I please, Madam? This matter pertains to settlement. I also recall on the previous occasion.
Yes.
Lordship, we have received instruction.
So you are going to do it without any further application.
No, Lordship, that number has changed. New that number has.
Understood?
Yes.
Kindly see your instruction. Let us read it. With reference to the subject cited above, I have to furnish here the required information regarding allotment of land favor of land measuring 6 figures. As reported by the circle officer by member, the land records have been corrected by grade dark 1078 for land measuring 1 kata 10 letter from the earlier dark grade by the other dark 840 dark it is clarified that no fresh application for allotment is but an application for the duty created is required.
Yes.
So we need not file any separate application.
No.
But we only
That is for Patta and mentioning the new that.
you do the need to
Only
give him a copy of
Yes.
it.
only apprehension being whether or not will be covered by the old land policy. For the allotment at the
No, the land has been already allotted.
Yes.
That is why my specific question is
yes, ma'am.
how much land was allotted?
6 figures.
So
At page-
for that-
Six figures. Page 25,
Six
ma'am.
figures.
6 figures.
Because the land has been done, so you are going to patta for that.
Yes.
So there is no fresh application. The land has been already been
Already
allotted, given.
That is.
Nothing
For allotment, no application.
to the person with the order did it on Mr. Dashboard was appearing the senior government appearing on behalf of the district commissioner in charge Dhemaji had placed an instruction to the effect that the land records have been corrected by creating new task number 1078 for land measuring 1 kata 10 letter from the earlier task number 486 under Mati Nepali Gaon map and another task number 3 42 from dark number 127 for land measuring 5 figures 3 tata 10 lectures under Torazan Gam. It was also mentioned that there is no requirement for the petitioner to file fresh application for allotment, but an application for issuance of patra mentioning the newly created task is required. The said instruction is kept on record and marked with the letter X. Mr. P. Chaudhary, appearing on behalf of the petitioner, submits that he would take appropriate, he would instruct his client accordingly to list the matter again on 8th of April 2024 for an update as regards the allotment, as regards the settlement proceeding in favor of the petitioner. The petitioner, who is waiting, the respondent, more particularly the district commissioner, have directed to take steps forthwith upon such application being filed with.
I'm deeply.
32,
May it please your lordship. The engaged counsel in this case had come to Bangalore lordship for her mother's treatment lordship. So kindly adjourn the matter for her lordship.
Who is the engaged?
Gitima Bora lordship. Gitima Bora.
You are? Earlier one L. Polwa was appearing. What is this matter?
Also a subsidy matter. So initial inspection was done by the GM, and there was no recommendation sent because certain machineries were.
Oh, you don't require the money. You'll have it in next year after 4-5 years. Taking into account that the petitioner have not filed the affidavit, taking into account the petitioner have not expressed presence, it's a matter of
33,
yes, what is it?
Finance and taxation has to file the affidavit.
What is this matter? We have made the finance and taxation a party.
Yes.
And it was said it's done.
Yes.
The finance and taxation is absolute. None appears on behalf of the finance and taxation department of the government of Assam in spite of service of notice. Has their name been told in the constitution?
In the constitution,
Not. The registry is directed to show the name of Mr. P. Gogoi, the learned standing counsel for the finance and taxation department, and this is the matter on 22nd of March 2024. So in the meantime, the respondent number 4 that filed that.
all right.
34,
Yes, what is your instruction? This court have duly taken note of the instructions so placed by Ms. S. Porwa, appearing on behalf of the district administration. Which district?
Gosaigaon. Gosaigaon.
Gosaigaon is a district.
Cooperative.
Cooperative. Which the said instruction is kept on record and marked with the letter X. This court fixes the matter on 1st of April 2024. It is made clear that the pendency of the instant petition shall not preclude the respondent authorities to take such steps as otherwise permitted.
35,
My lord, in this case, the petitioners have prayed for initiating the proceedings for acquisition of their land, which was requisitioned way back in 1956, my lord. Until date, no compensation has been paid.
Fund of the amount, but it might immediately make determination of the what of the right to pay. What happened?
But what has happened is that this is a tea garden, my lord,
Ah.
owned by a partnership firm and their legal heirs.
Ah.
So their land of 800 odd bighas were requisitioned by the government of Assam in 1956 to rehabilitate refugees from East Pakistan.
Ah.
And thereafter, there no compensation was paid for requisition compensation, and they challenged the order of requisition in the title suit, and that was allowed. Then government came on appeal, first appeal, which is with the record, my lord, and then this honorable court said that this the remedy lies in the act, that is acquisition and requisition of land, my lord, and we have to go there. Then we went there by filing application, but till date no
The
compensation.
requisition is going on.
Requisition is going on. Our land has been taken over.
No. Is it still under requisition?
Yes, my lord.
We have filed our application.
No, forget about it. What is this? 53 onwards, the requisition can go on.
My lord, this affidavit, they have accepted our averment.
Cannot- Not possible. Supreme Court has category of the done on the basis of a requisition. You can acquire the land.
Yes.
It has to be only for a temporary period. How can you do this? And this is acquisition done under what? Requisition done under prior to the 64 Act,
Yes, 1948.
1948 Act. Then comes the 64. Then, serious. On the basis of that, we set aside the requisition and pay them whatever amount. Serious respect. And pay the
On
amount
this
of
date,
compensation on day-to-day basis.
They've been taking
What is
our
the rent?
land revenue also, they are taking from us as part of that. Then they've
Revenue being
accepted
taken
it.
because of the fact that they are requisition.
Yes, ma'am. Because there is a team near the land.
And the loss which has been caused to you.
Yes, ma'am.
Serious.
In this.
Government
Your
has
in
been
affidavit
that-
initiated.
and your affidavit cannot help
Yes, but
what to do.
I have to take instruction of that.
Who is filing? What is the
It's a
election officer has to do with this?
But this
affidavit?
deputy commissioner has filed through the election officer.
Yes.
It's the matter on 11th of March 2024. On which date? The district commissioner, where?
Nagaman.
Nagaon, as well as the revenue department of the government of Assam shall apprise this court as to whether it is permissible to keep a land for under requisition since 1956
56.
and as to whether during this period the land requisition costs have been paid to the petitioner. Full stop. There's a judgment of the Supreme Court.
Yes, sir.
Categorically say that it cannot be done so. It will be a fraud. The word you
All right.
36,
have the judgment.
Yes, ma'am. I have to look for it. I have to look for it.
That is your main judgment.
Yes, ma'am.
Yes. Utah. What is this? NGO. Oh, that one. What is happening? The remaining amount. You have got some amount.
In this case, Social Justice Department.
That means that some more time may be granted to the respondents to obtain necessary as regards the status of the proposal for 2020-21 and 21-22. What happened?
Yes, Setting Council, Social Department of Social Justice.
And
With-
all
yes,
along, Mr. J. Henrik has been appearing. And now you are coming up with this new thing. Additional count. Mrs. Yudas has been appearing. And now you are saying that of additional count. Yes, this is a matter pertaining to mentally ill homes, where there has been, this court has granted you time.
Lordship,
You sought for
as
many
per,
times on earlier occasions.
telephonic instruction, my lord, they have given the required, my lord, instruction to senior advocate. I am the, it's not senior, I am the. Pending counsel.
And Mr. Counsel,
Okay.
should this court keep this matter as a continuing mandate? Your period is of 2021.
Okay.
You have got that money.
Not yet.
2021 is remaining, nah?
Remaining yellow.
But you have got the amount for 22-23.
22-23.
Instead
Today
of
also-
paying in the 2021,
Today also,
you are
my
paying for 22.
today also, my lord, they communicated, my lord, they have stated that they have already given the instruction to RM Das.
Who?
To RM Das Candidate Council. Social Justice Department,
Here's another one.
Lordship. Today also, my. Social Justice.
Social justice is not there.
Lordship.
Your government keeps on forming, changing the nomenclature of the departments. What is the petitioner going to do? You have the social welfare department is already there.
We have written,
And
my
all
lord,
along the social welfare department is placing before this court instructions. And now you are on one fine day, you are saying, and this is all being done by the social justice and empowerment department.
Lord.
They are submitting all these documents. And your name has not been. Can't help it. And all these instructions are given to the junior government advocate.
Lordship.
Then-
Now, my lord, they are saying, my lord, Mr. RM Das will appear and instruction has been provided to him. Lordship, may be pleased to record my submission here.
Okay. Mrs. Yuta, the learned additional senior government advocate submits that
Telephonic instruction.
pursuant to the order passed by this court on 2011-2023 and 10-1-2024. Instructions were duly sought for as regards the status of the proposal for the financial year 2020-21 and 2021-22. However, the director of the Social Justice and Empowerment Assam has informed her telephonically that no such instructions would be provided to her. Rather, the instruction would be provided to Mr. R. N. Das, to a counsel, namely R. N. Das. However, Mr. R. N. Das is not present before this court when the matter has been taken up. Under such circumstances, this court fixes the matter on 11th of March 2023 and directs the Director of Social Justice and Empowerment Assam to be personally present through video link to be provided by the additional advocate general, additional senior advocate at 10:15 a.m. It is however observed that if the counsel is duly represented, his appearance would be dispensed.
Lordship,
Our name may be reflected.
Absolutely no. You keep on changing. Earlier, every time, earlier. Why should we ask Mr. R. M. Das to file an application or do whatever? The court is not going to do. Our department keeps on changing. Earlier, social welfare was there. You could bifurcate or trifurcate to 4 departments out there. Well, what is the petitioner going to do? What is
Supplementary item 61.
Obliged.
Yes, madam. TD.
There was a direction to my lord to place the status.
Lordship, I have received the status report. I will provide it. Lordship. Lordship, this is status report.
Oh, yes, that matter. Where you
Lordship,
gave the wrong date.
my lord, actually, last occasion came, my lord, in the 2023, my lord.
From a perusal of this court by an order dated 7/2024 directed the investigating officer in the CID to produce before this court the updated status report. Pursuant thereto, a report has been submitted on 9/2/2024, wherein it has been mentioned that the investigation has been carried out and the FSL report have also been obtained. And from the same, it primarily appears that one Asadullah Kabir had forged the signature for which the case is found well established against the alleged driver Asadullah Kabir. It has also been opined that prima facie case under section 420, 467, 68, 471 of the Indian Penal Code was found well established against the said driver Asadullah Kabir. So the progress report of the investigation of the case has been submitted to the Superintendent of Police for favor for perusal and approval for submission of the charge sheet report against the alleged driver Asadullah Kabir, and the charge sheet is submitted against the said accused person. The said instruction is kept on record and marked with the letter X. So, list the matter again on 13th of March 2024 for an update as to whether the charge sheet have been duly submitted in the same.
Lordship.
Get it done.
Lord. Apply that.
Item 63 and 60.
In this case, Lordship has put us two questions to get these two status report regarding the mutation of the petitioner, and second one was the what happened to that application filed by the private respondent. Regarding that mutation, Lordship, we have the mutation has already been done, Lordship.
In whose favor?
In favor of the petition.
Which petition?
That Garudia.
He again has come now. Where is Mr. P.K. Roy?
He should have informed your Lordship on the earlier date that the mutation has already. It was not been informed before your Lordship. That is why your Lordship has directed her.
So, Kumar Garodia,
the mutation stood in favor of his
Ashok Kumar Garodia, son of late Shyam Sundar Garodia, Sri Santosh Garodia, son of so and so, and Dilip Garodia. These are the petitions. So first part goes lordship. Regarding the second part, that Nepal Chandra Day, as regards the status of mutation application filed by the petitioner in WPC number 7184, that is the second one. It is stated that the Sri Nepal Chandra Day has not submitted any mutation application in the office of the undersigned. He had submitted an application for correction. He has submitted an application for correction that I am coming to. He has submitted an application for correction of revenue record, which was numbered as file number so and so, and as per the report received from the circle officer, Dispur Revenue Circle, White number dated so and so. A hearing was conducted in his office as per notice dated 13/7/2018, wherein it was found that Nepal Chandra Day is not a recorded patadar, and the subject matter is not related to demarcation only, but after considering all aspects, it was seen that entire subject matter is related to title, right, and position, which is beyond the jurisdiction of the revenue authority. So this is the report we have received.
What about the demarcation?
That regarding the demarcation, Lord.
Yeah,
I
the
just now I have
for Garodia had thought for what?
Mutation, Lord. That
Only
is the order
mutation.
your Lordship has passed.
Copy of dated 13/7. What is 13/7?
That is the notice, Lordship, on the basis of the application submitted by the petitioner in the other writ petition.
Yeah.
That 13/7/2018 notice.
Now, this is in view of the finding of things given out there, that this is a question of title. Can the revenue authorities now go ahead with this 13/7?
No, Lord. No. That is why, Lordship, this is the report.
That is another thing. The other is copy to that. That is the only thing.
Lord.
Nothing else.
Nothing else.
So in view of his mutation has been done in the dark number what?
205.
No.
205 and there is 202.
No. Dark number 2335.
2335. By that status I have to know because my Lord, 205 comprising
No, wait. 2335 is 2.
No, from where it's scraped out? That is to be. It is further stated that dark number 2335 has been partitioned. May I place that will be better, Lord. These documents is not necessary, Lordship, only this.
So this is 2335.
Yes.
We are concerned with 2335.
Yes.
So it is now in the name of this petition.
Yes.
So that is that. And remaining is the other.
No, my Lord.
You are
Sorry.
yes, Mr. Lord.
I'm sorry.
In this case, your name has been mutated.
My lord, my name is mutated.
Then what?
The only thing, my lord, they are asking, they don't have a right title interest anything over the land, and they are asking a demarcation over the land.
Oh, now they say that Nepal today or Doyal today has no business over the land.
No
It's a
business over
question
there.
of title. And as such, the revenue authority won't do it, we will
Madam.
have to go to civil.
That is.
Lordship, my lord, my submission is that, my lord, they claim that their projected case is that 1962, they have get some settlement, 99 years lease from Toloi of Vasishtha temple. And in 1995, they applied and they got the mutation. Our case is that in 1966, we also get a 99 years lease. And then after 1 year, since this land has been acquired by the government under charitable endowment, we are the tenant, our settlement holder and the government of Assam, and we are paying revenue. But they are not given the government and not under government. In 95, everything is done.
Are you telling that?
No, they are 202. They are that number. They said
Again, 2335.
yes. Now 2335 craves out of 202 or 205. That is the question to be clear, because their settlement is 4 bigha, 3 kotha 12 lesa. Our settlement is
You are
4
in
bigha.
possession,
Not I am in possession. They are giving me.
and the notice was
Well,
they can't. You are asking. You have want to have
I want to know that my land, they cannot become the 8 bigha 3 kotha 12 lesa land. Admittedly, they are entitled to 4 bigha 3 kotha 12 lesa. We entitled to 4 bigha. Now, here when record attestation, my lord, what happened?
you have your name recorded.
Yes, with Patadar it is recorded, my lord, because
Your name is
no.
my lord, in settlement, my lord, this is the settlement. This is my lord, this Sanatan Dev Sharma, with whom he has transferred or he's given us the settlement for 99 years lease. After that, under the government of Assam, we are paying revenue and we are enjoying. And same is the case with them. Now, how our land can be deleted, because our duct and land measurement of land is different from them. Now, settlement officer or circle officer is reluctant to solve this problem. In spite of this, there is a direction, or in spite of this direction of this honorable court in earlier occasion.
so file a civil suit.
Because with against whom we should know. We should know that who is possessing our land. We should know, and whatever status of our land, that should be cleared by the settlement office, because they have the record. They should clear the where from 2335 come. Is this from 205 duck or it is from 202?
Owner's
not
name
made
are
clear.
there already, madam.
That was not made clear. They are reluctant to make it clear. In the meaning thereby, they become the 8 because of land. Where is our land goes, my lord? Because we are paying from 67 to 89, 2010. Revenue is there.
Toji, where are they are paying
Under the government of Assam.
Toji.
If anything is deleted, we should transfer it to them.
That means you have no right.
No right, madam.
My lord, mutation was done, record attestation. My lord, during record attestation, what happened, I don't know. So I made an query that we
No.
Yeah.
That
Yes.
people net.
Yes.
Take the
Yes.
now when you apply to your
Yes, that is why that is a mutation order, kindly see.
no.
Under the government of Assam.
Right to apply and that is the proper and the answer. And once you get that proper answer, that proper question, you know whether it's to go right. And this is not a complicated matter, unlike your considered property.
Well, kindly see, my mutation order, it's also here.
Again, I am not going.
Here says that by
Absolutely, I am not looking into. I am only asking you a simple
yes,
question.
yes, my lord, because
Whether
record
a
says
settlement has been granted to you, because if you see that act, settlement has been granted.
my lord, as far as this is dated 22/6/1967.
Is that a part of the record?
Yes, the mutation case number so and so.
Is that a part of the record?
Yes, my lord. Yes,
Which
my lord, in my petition.
Where?
Yes, my lord.
Malad page annexer E page 32, but it was Malad, I have Malad, it is not page is something, that is why I have
As per Gazette notification dated 66, the entire time
Malad, this page is something that is why I have given a proper Malad.
No, we should dismiss your petition on that basis itself. This is incomplete.
Malad, this is economist version is correct.
I
But
should have take it to the expert.
yes, Malad. But kindly see, I will
not going to
rectify it by doing this one. Here it is, mutation order is there.
We'll
Otherwise, how can I pay revenue, Malad? I can.
send it big for deregistration of the civil.
Malad, this is not.
No, absolutely. The great
Here, Malad, next part, Malad. Next part. Put in the call.
you cannot. If there any
Thing
intention
is that, my lord, we have got mutation before them.
the council nothing to can't do like this.
But where said then where this land goes, my lord? For
Where
reason?
he then goes is going to get for revenue or
Right.
not the
Then
this
on
vote
the
is not going
RTI application says that they have do not know. Now my learned friends submit another. I will controvert it by my lord,
Show
in my
me, no, show me where, when did you get your set?
my lord, 1967.
No, my lord, this is,
My lord, this mutation order is
You cannot get a settlement on 1956.
7.
You look into it, there is a requirement of a settlement to the people who are occupying it. To all the tenants under there is a requirement of settlement. What
Yes.
is required?
Yes.
Has that settlement happened?
Yes, because
Where?
we are in.
Now, where is the document in the writ petition?
Because in
Mr. Borua, where is the document in the writ petition?
in the
is
affidavit they
not
have
there.
given, my lord. In the affidavit they have given deed of settlement. Affidavit they have given deed of settlement.
With whom?
My lord, they have filed an affidavit in WPC 7184 of 2021.
Hmm.
This is a deed of settlement, nothing
yes,
else.
it is
Where-
they also a deed of settlement, my lord. They
No, no.
admitted that, but their land is not mutated. Our land is mutated,
No.
and they in
That mutation will cancel it. Don't worry. Don't worry. But the question is, where is your deed of settlement?
In the affidavit in WPC 7184,
Running page,
67.
deed of settlement. First party, second party. Where is the describe it? When is the deed of settlement? Date?
Date, my lord. This
No
is
date.
16366.
Where?
date number 4527 are then dated
What is the date?
16366.
Huh?
Page 68.
68.
1906.
Yes.
And when was the execution made?
My lord, after that, when we are in put in the possession,
When was the acquisition made by the government?
X will effect in 1/10/1963, and it is done. Executive has done after.
How this deed of settlement has any value? If it is done in the year 1966?
Yes.
You see, section 4 notification, which is section 3, there will be a notification, which will be followed by a declaration under section 4.
Yes.
But it will date back to the date of section 3.
Yes.
So, when was the date of section 3? Section 3 was in 1966, because in 66, the declaration was made on which of the acquisition has happened.
Yes.
So, under such circumstances, what is the deed of settlement has to do? As on that date, the Bokista temple had no business.
But they affected later on my period.
By it.
Malo, kindly see their case. Malo, kindly see their requisition. Malo, NXRA page 19. Kindly see.
Do one thing.
My
Place the matter again on 17 to 2024. And give you a lot of time.
17. 17 is a Saturday.
Saturday we are having court.
It may fix on 2 weeks, maybe.
65.
2 weeks.
On that day, wait for your
Lordship, my instruction may be.
the instruction.
Your lordship may
The 8th Sharma has placed a set of instructions which is kept on record at part. A copy of the instruction may be furnished to Mr. M.J. Borua and Mr. who can be in a position therefore submit, make appropriate submission the next.
Malo,
I may be allowed to give this
Huh?
I have allowed me rejoinder to keep the appropriate similarities with me, but
You want to give,
fine.
whatever.
But
I'm not saying.
I am sorry because for travel.
Don't make it.
Lordship is 15
Yes,
on
yes, yes, Miss Diane,
17 Lord.
17 to 2020. Yes, what is this? Oh, this one. What is this?
Item number 65.
65. What is?
Yes. In this matter, my lord, respondent had to produce some instruction regarding, my lord, their review of, my lord, the subsequent guideline they issued in 2016, my lord.
What
There-
happened?
Lordship, my seniority in the instructions are with me, Lord.
Hello, we'll have it after. It's a matter of 2 weeks at the request of the A director.
Okay.
Order the কাগজ order the কাগজ. Yes.
May I please your lordship? My lord, there are two petitions. One is a my lord complaint against non-compliance of the orders of this honorable court, my lord.
The petitioner, you are not filing your affidavit in reply.
My lord, the affidavit in reply is there, my lord. It has been wrongly placed in the my lord writ petition file, my lord.
Huh?
It is there in the file of the writ petition, my lord.
No. Are you going to file your reply?
They filed. I have filed. I
You
have
filed?
filed. Yes, my
Okay.
lord. On 29/5, my
No
lord, I have
counter
filed.
has been filed by the learned counsel appearing for the respondent. Then affidavit is not given yet by the learned counsel appearing for the respondent. to contempt application. No affidavit in reply. What is the violation? The truck bearing is in the custody of the police in Siman. As the vehicle is getting damaged, it is be released to the petitioner with due undertaking. After he takes possession, the borrower must resume payment of the current EMI to the bank. Then what happens?
Thereafter, the vehicle was not given to me, my lord. If the lordship finally seized my
Vehicle
lord,
was not released.
no.
Then
The vehicle was not released, and when we came up before this honorable court, my lord,
same can be in the area on the tip of the same. The officer in the asked the police to produce the document. However, the never done. As such, the department to the the data not understand whom the failure is. Okay, who is the owner?
I say, my lord, I am the owner. But now today they have come up with a set of documents saying that, my lord, they have seized my vehicle, and thereafter they have sold it to somebody else, my lord. Now the question is, my lord, if
Now,
my
when
lord,
did they seize the vehicle? When
They-
did they sell it?
yes, my lord. They say that, my lord, they have taken the vehicle and they have sold it.
So they have sold it.
Yes.
So that is good. One thing good about it, that they have sold it. So your money is there. Isn't it?
My lord, basically what happens is, my lord, that there were,
Registered owner petition.
yes, my lord,
Harjati Chaudhary.
my lord. I am
Now,
appearing
this
for
order
Harjit
was
Chaudhary,
obtained on 13/11/2017.
17.
And the order when the sale had happened was
Was on 6/8/2015.
Huh?
6/8/2015.
6/8/2015. Then
Now,
in
my
the
lord,
meantime, the sale has happened.
no, my lord, this was disclosed, my lord. Now the question that is to be seen by this court, my lord, now the vehicle is lying, my lord, in the Bhangagar police station. Had, my lord, there been a real owner who had been transferred with the vehicle or purchased it, my lord, he would have appeared before the court claiming for release of the
It
vehicle
makes
and all,
the
my lord.
claim. Anyway, when they are submitting,
My
they
lord.
must have put
Yes, they have sold it, my lord. Yes.
You have told it, so you have the transfer.
So in fact, my lord,
You can't say that.
so it,
No, no,
in
you
fact,
can't. No, no, Mr. When you are taking the base that you have told him, so you have to show that there is some document that you have
yes,
told.
yes, my lord,
There
is,
is-
they have given
Where is it?
page number 68, my lord.
Where is that document
But
that
Lord,
you
we
have
can
told him?
see, I'll just, so what has basically happened is, my lord, he availed loan, my lord, he failed to make the installment. Your lordship,
Mr. Day, I'm not concerned with
No, understand.
I'm only simple question is who have told it in the year 2015.
15.
Where is the document?
Page 67, my lord, Annexure G
Of
the affidavit filed by me, my lord.
filed in the writ petition.
So in the affidavit filed by the respondent number 4, 6, and 7 in the writ petition, but not in the contempt. The
7.
contempt, my lord, I have nothing to do. It is the, my lord, against the officer in charge of the Bhangavar police station. Now, Lordship will see, page 67 is the release
No, no,
letter.
where have you told to somebody?
Now, 69 below is the transfer of the RC, my lord.
No, where you have told it to others? Transfer to Konokta.
Konokda. This is the, my lord, new transfer.
5-1. There's been transfer.
Yes, my lord.
So this transfer happened in 15. Mr. Chaudhary.
My lord.
That
The vehicle, my lord, was seized, my lord, by the police on the basis of my complaint, my lord, sometime in the year, my lord, 2016.
understood, but as on that day, the owner was different, the vehicle. But you can't help it.
My lord, my contention before this court is today, my lord, if really there is a owner of the vehicle, my lord, it was really sold. My lord, that owner has been today before this court claiming for
Which
release of his
vehicle
vehicle.
number?
Vehicle is, my lord, AS25 AC 9444.
AS25, yes,
My-
it's there.
Yes.
The document is there.
Right.
So as on that date on which the order was passed by this court,
My lord.
the owner was different.
My lord.
So therefore, there is no need to file it.
Therefore, my lord, when the
Therefore,
word, my lord, owner
the
was
instant
qualified by the
contempt,
word
we
petitioner,
will
my
look
lord.
into the writ petition on a final day for it. First, I have to close this contempt because the contempt cannot come. The instant contempt application has been filed for violation of the order dated 13/11/2017. Passed in deputation number 486/2016, wherein there was a directive passed by the court to release the vehicle to the registered owner, bracket petitioner, which you undertake. It was also directed that after he takes the possession of the vehicle, after the petitioner takes possession of the vehicle, the borrower must resume payment of the current EMI to the bank. It has been alleged that in spite of the petitioner thereupon approaching the respondent in the contempt application, the said vehicle was not released. This court has really taken note of that affidavit in opposition filed by the contemptor, wherein it has been mentioned that when the petitioner approached the respondent contemptor about for release of the vehicle, the respondent contemptor sought for instructions from the DPO office, DPO Kamrup Aminga on 17/11/2017, seeking the details of ownership of the vehicle bearing AS25 AC 3444. 344. Or 944. To the said instruction source of court, it was mentioned that the vehicle was originally registered to the petitioner, but subsequently was transferred to one Konok Das, son of Nubin Das, village and PO, Kamarputi. under Nalbari police station. It was under such circumstances. Further to that, it has been mentioned that a state conductor had also appeared in the Bhangagar police station and demanded the vehicle. It is further, indeed, this court have also duly taken note of the form, the registration, the certificate of registration, which have been enclosed to Annexure H to the affidavit filed by the respondent numbers 4, 6, and 7 in WPC number 3486 of 2016. And from the same, it reveals that on 5/1/2015, the vehicle was transferred in favor of Konok Das. Taking into account the above, it is the opinion of this court that no case for willful and deliberate violation of the order passed by this court dated 13/11/2017 in WPC number 3486 of 2016 arises. Accordingly, the contempt proceeding then dropped. Be it as it may, this court have not decided in the instant proceeding as regards the legality and validity of the transfers so made in favor of the state Sri Konok Das, which shall, however, be subject to outcome of the writ petition in WPC number 3486 of 2016. This is the matter for admission on when this is the matter for admission 2016 on 15th of
Only thing that was to be pointed out that when the owner was qualified by the word petitioner, whether that officer could have made
but you can't make it now. You can also say that the petition, because you can, he
but
cannot
then he
release.
also have come to the court saying that
How can he release? He cannot release that person concerned. That person concerned, that's not a party. The officer in charge of the. And further to that, the directions also was not clear to whom. With due respect.
Hello, with due respect.
Yes, what is this?
40 to 47.
In this matter, we are supposed to file amended post title lordship. We have done so on 8/2/2024 lordship.
You have filed it.
We have filed the lordship, but it's not on record, your lordship.
Who is appearing?
Regarding
Now it was not new for new.
new manner notice probably
Don't worry. We can very well impose. Who is the new one? New one is.
whether the ATS is that
Hey, have you filed that the memo party?
Lordship, we have filed it. We filed it on 8/2, your lordship. So lordship, that thing is lying in the section, your lordship. In the notice of 8/2, lordship. That's why it's not.
8/2 you have filed.
Lordship. There was some delay on our part.
The record reveals that the notice that the petitioner have only the petitioner in the back of the contemporary applications have only filed the fresh memo party as directed on 8/2/2020. Taking into account the above, is the matter on 1st of May 2024 after completion of the
48.
Yes.
Yes,
Now tell me,
Madam.
you want to withdraw?
Because
Let us see
the petitioner is not inclined to continue the matter, madam. They are not seeking for their money yet.
They want to withdraw because what is the direction?
Non-payment of contractual bills of irrigation department.
Yes.
Where is the remaining part of the order?
My lord, in this
Which order?
page number, page
At page
number
14.
14, my lord. There,
Huh?
in 14,
You are asking for then it is what? Then it is the contempt order.
contempt order. This one, I had ordered the common order dated 26/2/2018.
Justification of eating the cap. Now, where is the direction?
Direction,
What
well,
is this
in
page 10 and 11? Kindly see. Where is any direction?
yes, my lord. There's a one mistake, my lord. The page number 10, 11 is not inclusive.
Zero.
But
11 has nothing. There is
yes,
no
my lord.
direction.
Yes, my lord. But in my another case, this order is there, my lord. But in this case, this paper was not, page is not enclosed. But in this, as per this order, my lord, in page number 3, the
It is after the page that for the purpose of compliance, the quantitative 17 foot of the 17 various documents have been sought for by the concerned respondent court for carrying out the verification. However, the petitioner is not in a position to furnish such documents. So, taking into account the above, it is the opinion of this court that the instant contempt proceeding, therefore, is not maintained against the present contempt in view of the fact that there appears to be no willful and deliberate violation to the order of the according to the contempt proceeding. Therefore, you can't withdraw the difficulty. I can't even withdraw. I can't dismiss for default vote.
yes,
It's a very difficult.
yes.
Yeah, what it is.
In both the cases, my lord, we have taken second time steps against the newly implemented respondent number 12, my lord. But as per office note dated 7/2/2024, my lord, service report is awaited again, my lord.
So I
50 and 51.
51. This service not complete. This is the matter after. Yes. They filed affidavit.
Yes, my lord.
Yeah.
But the return order has not been passed, my lord.
Huh?
But the return order has not been passed.
What return?
Return order.
Who has not passed the return?
The respondent proposed, my lord. Because, my lord, the earlier PO has been passed. The new PO has been accepted, have communicated, my lord.
What affidavit you have said? What is the order?
My lord, their affidavit may be seen, page
Wait
5,
the
para
order.
9.
There is the office note, it reflects the order. Where is the order of taking of time? Consider the this court. Period of 1 month from the date of. Then he gave the 1 month. That it has been given directly given to whom? Usually it has been given.
Project director.
Then they have not done. Now you have filed an affidavit. What you will say that
Affidavit may be sent para 9, page 5.
that is it,
Affidavit by PD, project director. Affidavit by project director. Filed on 11/11/20.
11.
It is filed by PD.
11. Who says the paragraph?
Paragraph 9 may be said.
Yes, everything is looked into. Have you passed any order?
But my lord, already has getting the order. But in the meantime, the CEO has been transferred. The new one has
What
been.
is this order of 411,000? You were supposed to pass an order. What happened?
My lord, 1 week time may be done with a pass you. 1 week time might may be done.
Sir?
As from.
As from my appearing on behalf of
BK, respondent number 1.
one submit that that on account of various transfers which have transfers and new incumbents joining the post of
PD or project director.
the project director DRT, the order which was required to be passed in terms with the directions passed in the order dated 6/12/2009 would not be passed. He, however, submits that presently the new incumbent with the project director DRT Corpeta would pass appropriate orders within 2 weeks. It's the matter again on 15th of March. For an update.
If job
53.
Third is not complete. It's the matter.
$54.
It's the matter.
$55.
Yes.
My lord, as per direction of this honorable court, my lord, file affidavit.
Who has filed it?
Petitioner, additional affidavit.
Hello. At the end of the day, I don't want to dismiss your petition today.
Yes.
See, I'm going to one fine day it is going to be. I give you a date when you want the death of the petition. Well, whenever you feel like the review will be dismissed. There is no quarrel. But you want the, I am giving you the liberty to choose a particular date. When? This month, next month. Eh?
This month. This month.
This month I am not. Next. Let the matter be listed on 14th of March 2020. On which date the same shall be made.
56.
Yes.
A review, Malad, for pensionary benefit, he was entitled to get 7 pay commission, but 5th pay commission was paid. And my lord, because the council was not present before the honorable court, your lordship on the basis of affidavit has declared the order. That is at page, my lord, 194 and 195. And they have filed affidavit to that extent, my lord. Government has filed affidavit. Your lordship.
What do they say?
So, my lord, I have
You're not
given this to the person concerned, my lord, petitioner, but he is bedridden. He wants to reply. But, my lord,
You fought for
my lord, because he is
instructions
the old
last
man,
time
my lord, I tried to contact him quite.
You fought for instructions many times earlier.
My lord, I have given him a call, my lord, but because of his physical ailment, my lord, as a last chance, my lord.
1812, Mr. P.K. Roy shall be appearing on his for an accommodation to obtain into of the affidavit.
I concede to those, my lord.
On him. Then on 10/1/2024, Mr. P.K. Roy sir submitted that he has yet to receive it.
My lord.
That's then what is wrong?
My lord, only for the last.
Why?
Only because to the affidavit, if he can say something, my lord. Because he has made some statement. And so, as an old man, my lord.
We have already provided whatever he is eligible.
It's not eligible. So my order was
your lordship on the
On
basis
the basis of affidavit, that order was passed. At that time, already we have stated whatever he is entitled, we have paid. Not it.
It has to take it.
My lord.
Before P.K. Roy submitted me. Thereby, not have
Obliged.
Service not
For number 2, my lord, I would not to allow me to time to file my affidavit.
You file.
Got it.
Next time it says I have taken to pass. The pass an order to the yes, what is it? Mr. Espora appearing on behalf of number 2 6 accommodation for filing a reply. Affidavit is none appears for the 1 and 6. The record no authority that the service of the respondent is not it's the matter after 6 weeks with an update as regards service of notice of the respondent of the the petitioner respondent number 2 shall file their reply.
58.
Madam, we'll take up this matter again another day. It's a very important matter. There's a far-reaching consequence to another matter. We'll have it on. Let me come back on 5th. It's the matter again, 5th of March. For at the top of the list. This is the important. Has anything happened?
We have not seen any communication.
Not sure for central government.
So they have,
That go for the retired.
yes. So they are
Now,
facing
nothing has- they have put up Otherwise,
per their instruction,
Good,
Lord.
good, good problem. We may have to direct take up all your
Lord,
and
we are
take
likely
it
to
to the-
receive some instruction with
or we have direct picture to take up all but let's see back
66.
With your lordship.
what about the service? No affidavit has been filed by the learned counsel for service upon service upon the report is the service upon the it's not complete. The learned counsel effect public that may permit the express step for the table. It's the the matter when everyone-
19/8/2020.
you see many of these people are no longer there. You are for what payment.
Yes, lordship. Yes, lordship.
Not payment of just take it out. I think I will adjourn it for 2 weeks. You just get your instruction and then find out as to what happened, as to whether these persons are there. It's a matter again. 6th of March. In the meantime, the petitioner shall obtain necessary instructions.
Highly obliged, lordship.
6768.
May it please your lordship. According to order dated 19/12/23, lordship, I have taken steps on the as per the order, lordship, and lordships had called for an affidavit from respondent number 4, lordship. It has not been filed.
This matter,
It relates to the amnesty, lordship, in bamboo industry.
but they have not filed the affidavit.
No, lord.
Serve notice.
Respondent has appeared in the sixth has appeared in the analogous matter, lordship. But
With respond number 11.
that one is private respondent, lordship. Cotton Forest Products Limited. Another.
Oh, so the
contender.
appearance is complete.
Yes, sir.
The appearance search all the respondents is the matter of the 2nd of March 2024. In the meantime,
Lord, may I pray that I'm not sure whether my senior is available on that day. It
who
may
is
be
your senior?
Mr. K. Chaudhary, senior advocate.
Whereabout? I don't give on dates on the basis. When do you want it, madam?
2 days earlier, Lord, because I'm told that you would not be there on the 19th, 18th, 19th. Eighteenth with your
2000.
deeply.
In the meantime, the respondent number 4 is given an additional opportunity of filing the reply as directed by order dated 19/12/2020.
detail.
Yes, any other matter? What is this matter? 59?
This matter, substitution petition filed that
Oh, that one.
was
That person died, na?
Correct.
This IA is there.
Correct.
We have to pass an order on the IA.
Correct.
Hello, let us pass the order on IA. We have passed the orders. The instant application has been filed by the petitioner. You're a petitioner?
Correct.
Petitioner. The seeking substitution of the legal heirs of the chief respondent number 10. The record reads that the respondent number 10 expired on 28/8/2022. However, the said aspect of the matter was brought to the notice of this court on when?
9/1/24.
9/1/2024 during the course of the hearing by the counsel of the deceased respondent number 10. Under such circumstances, the instant application has been filed, thereby to impede the legal heir, the legal representative of the deceased respondent number 10. This court is of the opinion that the right to sue survive upon the legal representative of the respondent number 10. Accordingly, this court therefore substitutes the legal representatives whose names have been reflected in paragraph number 3 of the application as against the respondent number 10 and impledes them as the respondent number 10-1, 10-2, Roman 2, 10 Roman 3 to the instant writ petition. Full stop. The petitioner to the accompanying writ petition. The petitioner is directed to submit a fresh memo of parties before the registry on or before 17/2/2024, and on the basis thereof, and the order passed herein, the registry shall make necessary changes in the cause title and update the same in the CIS. Full stop. Our main writ petition on left. Taking into account the order passed by this court in the accompanying interlocutory application being IAC 364/2024, whereby the respondent number 10 have been substituted by the respondent number 10-1, 10-2, and 10-3. This court directs the petitioner to issue notice of the instant proceeding by issue notice upon the said respondent 10-1, 10-2, and 10-3 by registered as well as usual within on or before 17/2/2023. Which list the matter after completion of steps.
Ada tes again.